that
It
smoke's
doesn't
covering
matter.
energy.
I would still be cold usually. It's the smoke.
All right, we're recording.
All right, this is docket 26427CH, Emily Neighbor versus Brandon Sanders. I think you're both in pro per, is that correct, as I recall?
That's correct.
Yes, Judge.
All right, and Ms. Neighbor, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
And Mr. Sanders, Colonel Sanders, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
All right, thank you. Can you put your video on, or is it not working?
My end says my video's on, ma'am. I apologize. Stand by.
That's okay. If you can put it on, great. If not, that's fine. All right, so this is, looks like it's plaintiff's motion to partition. So I have a couple of questions before we proceed. Is this property for sale?
No, it's not for sale right now.
Are you both in agreement that it be for sale?
I'm motioning partition for sale.
Okay, but that's why I understand the motion.
No, ma'am.
I just want to. So one wants to sell and one does not?
That is
So
accurate.
ma'am, do you, okay, so, Colonel, you want the property?
Yes, ma'am.
Are you willing to buy her half from her?
I'm petitioning for partition in kind.
So you both want to split the property? You keep half, she sells half?
I think,
Ma'am?
yeah, I think that's the disagreement, is that I don't think the property can be divided because it's just one building on one parcel. So that's why I'm asking for a partition by sale.
You want a co-owner then? That's what I was gonna ask, because I was under the impression before that it was when you all were here last time, that there's a building, right? So how do you partition this building?
Well, ma'am,
Just a minute, sir. Ma'am, how are you proposing to partition it? I mean, a lot is one thing, but a building is a completely different
Yes.
proposal. It's an impossibility.
Right. So I think that's my motion is to partition by sale because I don't think it can be divided fairly.
So you want to sell half a building?
Correct.
Is this, I have not seen the property, is this 2 condos or is it 1 home or what?
It's like a single residential home that was converted into 2 apartments.
Okay. Colonel Sanders, do you want to own all of it? Can you buy her out?
Ma'am, I'm currently unable to buy her out personally. However, I am in favor of her using the funds that she receives solely from our other rental properties that she receives solely.
Okay, wait. So we're confusing. Is there another piece of property the 2 of you own?
Yes, ma'am.
And so what's the agreement there?
The agreement there is the same as this property, ma'am. We co-own it, and we rent out properties for low-income families and low income communities.
So who owns that property? Both of you?
Yes, ma'am.
So why doesn't one of you own one property solely and the other one only own the other one solely, and then you figure out the difference and one buys the other out? What's wrong with that? Because I can't cut a building in half. Have you 2 talked about that?
I did make a proposal for that, but I didn't hear any response.
What's your proposal, ma'am?
I had made a proposal that basically we pay off the mortgage for this property, and from that, then I would own the other 2 properties, and he would own this one fully.
What do you mean we? So you two are not dating anymore, right?
Correct.
Okay, so you end up in, how many total properties are there?
3.
Okay, and you both own all 3?
Correct.
Okay, and are any of them paid off?
One of them is paid off fully, yes. Then the other 2 have
And then-
mortgages.
Okay, and is that one being rented?
They all are.
Okay, where's the money going? Are you dividing that money, ma'am?
The money goes to paying the cost of the properties.
So you're not making a profit at all on any of the properties? You would be making a profit on the one that's paid off, isn't that true?
Yes, so when everything is basically added together, sometimes the rent has to cover the, like what, for example, this property in Lansing was vacant for several months this past year.
Wait a minute, was vacant for several,
Was vacant.
vacant for several months? Is that what you said?
Yes, vacant for several months. So then at that time, I used the rental income from other properties to pay the mortgage for the property in Lansing.
Okay, so have you two formed a limited liability company, corporation or something, or is it just the 2 of you running this?
It's just the 2 of us.
And you two can't get along business-wise?
That's correct.
Okay, how about we get a third party to do that, or I put them all for sale, or I'm not gonna partition a building like that, because now there's gonna be problems with the assessor, I don't know what other problems you're gonna end up with, but technically, ma'am, he's on duty, he doesn't even have to appear here. So he's been appearing, he wants to be part of this suit, and I don't understand why you two can't, what's the problem with working with him with the business? Are you disagreeing on things?
I don't think there's a problem working together on the business. I think I just don't want to own the property anymore. So I would like to find a way for us to end our co-ownership.
Then you need to put all 3 of them up for sale. So Colonel, how about the one that you own fully? Can you refinance it and pay for out of the 2 buildings and then have the rent pay for the cost? Is that possible or no?
Judge, I appreciate the question. Anything is possible. If I may speak to the how the profits are being dispersed.
Yes.
The profits that are made from our rental properties that we co-own, those profits are solely going to her. She recently cut me from our joint accounts.
Oh, wait, stop there. The joint account, I get it, you're not dating, you're not living together, but there must be one business account that both names are on. Is there, Ms. Neighbor, did you cut him out of a business account?
There were 2 accounts that we had, and Mr. Sanders took all the money out of them last year, and so once the balance was at 0, I closed both of the accounts.
So where's the business account that runs all these 3?
I have an account that runs all 3.
You have an account that runs all 3, that all the money is going into on these 3 properties that are jointly owned?
Yes.
Oh, no, ma'am. No, that's a problem. If you jointly own, then you both have to co-own a business account. And he gets to see the accounting.
Yes, I do provide the accounting. I've provided him with a shared document where I account for all income and expenses, and I've also sent him statements from the account.
Okay, Colonel, has that happened?
No, ma'am, I haven't seen anything. I've recently received a no contact order from her because she filed false allegations here against me in Europe. I was not permitted to engage with her at all, talk to her at all. I have not received not 1 cent of the profits that was made from any of the rental properties that we co-own.
You need to slow down, sir. Sir, slow down. I got a court reporter here who's taking everything down, and your words are all running together. I know you're excited and angry, but let's just slow it down.
Yes, ma'am.
Okay, continue.
Yeah, I have not received. I'm not aware of any accounting statements that were sent to me. Additionally,
Okay.
ma'am, I have not received any profits from any of our rental properties. We co-own.
Okay, so here's what we're going to do. Well, first let me ask, what is your solution to this? Let me see what the two solutions are so I can make a decision here.
Do you mean
What's your
for me,
solution?
Judge, or?
Not you. Colonel, what is your solution?
Ma'am, I came here to prepare to speak to the home and land fund, not the properties. My position is that partition in kind, I believe that the property can be divided equitably because it is converted as a duplex and is currently being rented out, as a neighbor stated.
So you're gonna find a co-owner that you get along with?
I'm sorry, ma'am, I don't understand the question.
So in terms of the partition, are you, Ms. Neighbor, are you suggesting for the petition, you want to sell your half, right?
Correct, yes, I want to sell my house.
Okay, so Colonel, you would be then working with, I don't know whom. Are you willing to do that?
Ma'am, I'm willing to aid and assist and getting this property partition in kind. Yes, ma'am. Yes, ma'am.
So what about the other properties and accounts?
About a year ago, ma'am, I requested my half of the profits in arrears. Additionally, regarding the home in Baltimore, I was currently living there, and I requested that she remove that tenant from that property because it was rented without my consent and it was leased without my consent.
So is this the one that's paid off in full, that's owned by both of you? And is this Baltimore, Michigan?
Yes, ma'am.
No, Your Honor, if I could clarify something, the other two properties are located outside of Michigan. So at this time, I have filed for partition suits in Maryland and Chicago separately for those properties. So I think we both maybe, well, I'll speak for myself. I think in this hearing, just want to deal with the property in Lansing.
So, okay, that wasn't made clear to me. So the properties, you have properties in 3 states?
Correct.
I don't know, you can maybe partition. Sir, you may end up in a worse situation. I don't know who's gonna buy it or what the situation is gonna be. I don't know why you all just don't sell and start over or buy each other out, especially if you've got one that's paid off, you can sell it, sir, you could buy her out. I don't know how you're running things being deployed, but whatever. All right, so here's what we're gonna do. Yeah?
Sorry to interrupt. I recently filed a motion for a stay because I'm currently deployed.
Yeah, you're entitled to that, sir. I think we talked about that last time.
Yes, ma'am, and I filed the paperwork, and I'm just awaiting the decision from the court.
I haven't seen one.
We have not, did you file that here with us? Let me just check I don't have that in my file, but let me check the computer, because sometimes they don't come up from the clerk's office. Let me just see.
I looked at it this morning and didn't see it.
When did you file that?
Ma'am, I filed about a week and a half ago.
And where are you deployed? Is it Germany?
Yes, ma'am. I'm currently assigned to Ramstein Air Base, Germany. However, I'm assigned to the
So it just may not have reached us yet. So, ma'am, I'm confused about something. He says he hasn't received any payments or bill receipts or any of that, whatever you're doing.
Mm-hmm.
But it appears he has received what you filed with the court. So, sir, how is it, are you sending it to the same address?
I have sent it to his email address, and the accounting spreadsheet it's a live link that he has access to.
So he has the passwords he got?
It's just a shared document. So I can provide the court with the proof that I've sent all of that to him.
So, sir, have you looked at your links on the live sheet, or don't you have access?
Ma'am, I have no access to any live links, and I have not seen anything that she's claiming that she sent me, nor have I received any profits from any rental properties that we have.
Okay. I'm willing to consider partition after you all agree, ma'am, if you need to open up a business account with his name, and he needs to have equal access. And all the accounting from all three properties, because you're located in Michigan, I do have jurisdiction over you. You are in Michigan, aren't you?
I
You're in
don't,
Washington?
correct, yes.
Yes. But the property's here.
The property is in Michigan, yes.
Okay, well, you need to share before I can partition, I want to make sure that all of the accounting is done and any bank accounts are joint to have equal access. If you have equal ownership, you need to have equal access, and then when the property is sold, the monies need to go in there and to be properly divided or whatever. I don't know how it's gonna all wash out.
Yes.
The other thing I can do is get a receiver, but that's gonna cost you both money.
I'm happy to provide the full accounting to the court and to Mr. Sanders.
Great, and what about on this business account, his name should be, if this is running the business of both of you, I'm unclear how you made yourself president and cut him out. Because essentially that's what you did.
Well, like we had discussed before, we did have two joint accounts, but then once Mr. Sanders, he transferred all of the money out of it. It was about $4,000 total. He transferred it all to himself. And so the account balance for both of those was at 0. So at that time, I closed the accounts because they had auto payments tied to them. I didn't want them to go into overdraft. And so
Yeah, I got that. Let me ask him, Sir Richard, did you drain the two accounts?
Ma'am, that's a mischaracterization of what happened. Ms. Neighbor filed frivolous allegations here against me in Europe, and
So what? How does that relate to you taking money and closing the accounts? That's a solely different issue.
Ma'am, I informed Ms. Neighbor that I was pulling money for legal fees.
Who made you entitled to? How are you entitled to use that money for your?
Because of the claims that because of the allegations that she filed against me here in Germany.
Sir, it doesn't work that way. A judge has to order that. She paid you. Those were joint accounts. I don't know, you two, and those were for business?
Yes, ma'am. Yes, ma'am, I understand that. And I had access to the funds, I had rights to the funds, and I used those funds accordingly. And in defense of myself against the false allegation. That is accurate.
The funds were for the property. Is that what it was for? Were those two accounts personal or what?
No, ma'am. The profits were for a wide range of things. For maintenance costs, all things administration, and then split disbursement, and any profits were to be dispersed between her and I.
But you didn't disperse them between you and her. You took them all.
No, ma'am. She's already received. At the time, she has already received all funds from our other real properties.
And how did she receive them?
Okay, for example, ma'am, one account for the Baltimore property, ma'am, that goes straight to her account via Airbnb.
So you're saying that that's an offset to the money you took?
Yes, ma'am, precisely.
Okay. Here's what we're gonna unwind all of this. Some other court is gonna have some real big problem too. You got problems in 3 different courts. Here's what we're gonna do. You want me to partition? I want a clean slate between the two of you. Because otherwise we're gonna have other money problems, and I'm not interested in entertaining this sounds like a Judge Judy case. Seriously. The two of you, before you own any other property or enter into business, need some business classes. You don't run a business like this, and I am shocked that the IRS is gonna slap both of you. I don't even know how you're gonna claim deductions or any of the other things. So you all need to work together to figure out the IRS deductions, income, all of that, because something's gonna happen here, and neither one of you are going to be happy. And sir, you know the Army rules, right? Or the Air Force rules. You have to be above board and everything. They can get you on conduct unbecoming. I suggest you clear this up, and I understand that your feathers are ruffled and you're saying it's all her fault. She's saying it's all your fault. Let's take this opportunity with this judge, who is pretty patient for these things. A lot of judges would just throw you out and let you go to the wind with the IRS and the other two courts. But they're not gonna do that, because there is a solution here, and you two need to grow up and be business partners. I don't care what happened in your relationship, and neither do your tenants, and neither will the IRS. So here's what we're going to do. Sir, you are going to provide an accounting of the money you took and how it was spent. Ma'am, you are going to provide an accounting of all of your properties and your bills and all of that. And then there'll be spreadsheets, and we'll see who owes who. When I'm satisfied, then we'll partition it, and then we will see who owes who when that other half is sold. Because right now, it sounds to me like monies are owed to one side or the other. We're gonna partition, there's going to be a fight over, there could be a claim over the monies once that property is sold. He could have a claim saying there was damage, or you owe him for these other properties, or whatever have you. So let's untangle it now, and then I'll order the partition, and we'll have a clean slate, and you can go on your merry way and ask the other courts for a partition with everything being paid and done appropriately. There should be a business account you both have access to, where the money goes in, the bills are out, and ma'am, if you're the one that's been paying them and you're here and he's on duty, then you manage it and you give him regular accountings. And like I said before, he doesn't have to do anything, because he's on military duty, he's on active duty, so the law provides that he doesn't have to worry about any lawsuit regardless of what kind it is. So, are you both willing to untangle this or what?
Yes.
Yes, ma'am.
Sir, can we get that? Okay, because honestly, you both have a responsibility to clean this mess up. And I would hate to have the IRS or anybody else slap you with fines, late costs, income problems, or whatever. It's just, there's ramifications beyond what you have even thought about. So, ma'am, you're gonna open up a business account, send him the forms so he can sign them, and then you're going to keep track of everything. You're both going to have 30 days to provide a sheet of, sir, as to what happened to those, the two accounts she's claiming, and ma'am, you're gonna have 30 days on the rest, and then we'll see who gets an offset for what. And we'll figure it out, and then I'll order a partition with any monies that goes, if you get more money, ma'am, then you get it, and if you owe him, then we'll figure that out, so there can be a clean partition and sale. And that way you've got 3 properties that are clean, you're asking other courts for partition, and then we don't have these money issues. That makes the most sense to me. Now, sir, I haven't received your stay. If you still want to stay, that's fine. We can talk about that in 30 days. You are entitled to it based on your military duty. I don't know, is 30 days enough time based on your duty and your access to records, sir?
Ma'am, I'm gonna do whatever you asked me to do. In my filing, I requested 120 to 180 days.
You requested what?
120 to 180 days stay.
Okay. Well, I don't have that yet, so, I mean.
Understood,
And she
ma'am.
hasn't received it yet. We can address that, when I get it. But meanwhile, I think it's important. Do you want another 180 days of bills you don't know about?
No, ma'am.
Right, and ma'am, you want this partition, so the sooner you all get the records to me and to each other, you can't just send them to me, you have to send them to each other. Then the sooner we get this done, and can I do a stay? Absolutely, but I think we need to get this money handled, because the money's ongoing, and your renters are at risk too. You guys could have a lawsuit from your renters if things aren't paid, or what have you, so let's not, I mean, basically, you've got a pothole here, let's start filling it up instead of making it bigger and stuffing into it. 30 days, I want paperwork or reason why you need an extension, and then we will reset this in front of me, let me get it. And then, sir, if you want to handle your stay at that time, that's fine too. Is there, I don't know what your duty station, what your, you know, I know there's, you know, regular meetings and all that stuff, been through it myself, so is there a day that's better for you? I usually do these things on Wednesdays, so I can do it a different day. Is there a day or time that's better?
No, ma'am, I'm gonna acquiesce to the court's discretion, and I'll make sure I'm where I need to be.
All right. Let me just do September 2nd at 1. That gives you the 30 days to get everything and then review it. So September 2nd at 1, and we can do it on Zoom. And that hopefully is the mailing time. I don't know, is it probably taking a couple of weeks to get to Germany? I mean, we could make it maybe the 9th. Let's make it the 9th at 1 because I'm worried about the mailing time. If you haven't received some of the things she sent, I do believe that she has sent you information. I don't know where it's going. Have you received, I mean, you've received the legal documents she sent, right?
No, ma'am, I've received, only reason I know about this is because I looked online and saw it.
Okay, does she have your mailing address?
While we were together, I have the same email address, ma'am.
Is it email? You want everything by email, not mail?
Email is helpful. Mail can get a little crazy out here due to the current conditions in the Middle East.
Okay, so let's do email. Does she have your correct email, or have you blocked her and that's why you're not receiving anything?
Ma'am, I received the no contact order.
Okay.
So I don't have any means of communication with her or contact her.
Well, you're allowed contact for court, and certainly, ma'am, you're not feeling threatened by being in court with him. You want resolution, right?
Yes, I do, and the no contact order did not come from me.
You didn't file a personal protection order?
No, I did not.
So somebody else did?
I'm not sure.
Okay, well, if it's not you, I'm not gonna worry about it. I don't know what's going on there. And I don't have to know. So, sir, what is your email?
BLS
B what?
dot BLS dot USAF at gmail.com. I'll drop it in the chat for you, ma'am.
Thank you. So, ma'am, is that the BLSUSAF@gmail.com? Do you have that one, ma'am?
Yes, and I've provided evidence to the court of all the emails that I've sent to that email address.
Okay, well, right now, what we're gonna do is we're gonna get this accounting and all this done, so, I'll grant you the partition after we look at the money and we figure out who owes who, if any, how the money's gonna be run, and then when this partition occurs, because I'm not gonna close the case until you sell it, hopefully it'll sell quickly, and then we can figure out the finances, because I have a feeling neither one of you are going to agree. Unless you don't want me in the case and you guys want to hire somebody else or have your realtor do it, but it sounds to me like this is a big mess. It's a relationship mess, and certainly I can untangle that. Is that okay? Both of
Thank you, ma'am.
Yes, thank you, Judge
Okay.
Aquilina.
All right, if there's any problems, and we need to chat on a lunch hour or something without a hearing, that's fine. But we can take up the stay, we can also take up the partition, and we'll take up the financing on that September 9th at 1, all right? And that's
Yes,
1 EST time, sir. I don't know, Germany is about 6 hours difference, right?
That is correct, ma'am. It's currently 16:22 here.
Okay, so that's an okay time for you?
Yes, ma'am.
All right, thank you. Thank you both for your patience with me. I will look forward to the resolution of this. And ma'am, you probably want to talk to some realtors and keep him apprised of which realtors you both can agree on, realtor, for the eventual partition and get some information so we can really move forward on the 9th. Is that okay?
Yes, ma'am. Thank you.
Great, thank you. That's all. This is docket 261161 NF Farm Bureau General Insurance Company of Michigan as subrogate of Deborah Lewis versus Rita Joyce Williams, Allstate Fire and Casualty Insurance Company, Allstate Indemnity Company, Allstate Insurance Company, Allstate Property and Casualty Insurance Company, and unknown insurers, 1 to 3. Okay, and counsel, your appearance for the record.
Elizabeth Johnson on behalf of Farm Bureau, Your Honor.
All right. Thank you. And I have the law offices of Jonathan Hayes in Chicago here. Daniel Zick is the person who, I don't know if he's licensed in Michigan or not, probably is, but I don't know. But he's not here. Have you talked to him?
I don't believe so. I don't believe any conversations were conducted, but I do see that there was something submitted for a scheduling conference, and we have no issues with this. We can stipulate to it.
And is this what they submitted or you submitted or?
They submitted.
All right, well then sign it and provide it to me. I mean, if this happens in the future, just, you just need to talk.
Yeah.
This case isn't gonna go well if you don't talk, because I'll sanction both of you. You gotta talk and not waste my time. Scheduling conferences, I see 1% of attorneys on this. I see about 90% of improper, which is expected, but council's expected to talk to each other. Please do that in the future, and please approach with it, sign it, and I will sign it as well, and we'll give you copies.
Thank you.
Do you have it with you?
I have a copy digital.
Okay, don't leave yet. Brian, if you could send it to my law clerk, we're gonna print it, I'm gonna sign it, and you're gonna sign it. I like one-stop shopping, and we like to get things done today. So, Mr. Ring is going to help you, and if you just wait, he's gonna print it, we're gonna sign it, and we're done. So that's gonna be the order. We'll make sure we give you copies, and we can send that, you can send that to everybody. The other side is failed to appear, But it does seem that you're using theirs and there's agreement, so there's no reason to belabor this. This case needs to move forward. That's all for the record, just wait here till we get the stuff. Thank you, next matter.
Next would be criminal. Who do you want first, Clark?
Justin Garcia.
Or did you give her?
Yeah.
Okay. This is docket 18500FH, people of the state of Michigan versus Justin Ronald Garcia. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan here with probation.
Good morning, Your Honor. Agent Jessica Farr with Ingham County Probation Department of Corrections.
And good morning, Your Honor. Frank Harrison, Ingham County Public Defender's Office, speaking at a normal speed, here on behalf of Mr. Garcia, who appears in person and standing to my right.
Appreciate that, counsel. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth, and the penalty of perjury?
I do.
Thank you. And put your hand down. Are you taking any medication, using the alcohol or marijuana yesterday or today?
Medication, yes, no alcohol or marijuana.
Does the medication interfere in your ability to understand your attorney or the court?
No,
Is there medication you're supposed to be on that you're not on?
no,
All right, and you had enough time to speak with your attorney?
I'm sorry.
You had enough time to speak with your attorney?
Yes, Your Honor.
All right, you pled guilty to uttering and publishing attempt, which is felony punishable by 5 years. You were placed on probation. Part of your probation included that you would participate and complete the House of Commons. I now have a bench warrant that was requested, and this was done in, I signed it. It was requested by then probation agent Justin Russ. I signed it 6 years ago, 20th of August, 2020. So just shy of 6 years. And it alleges that on August 21st, 2020, defendant absconded from House of Commons. Counsel, you're waiting further arraignment.
We would, Your Honor.
Will there be a plea or a hearing?
My client is prepared to plead as guilty as charged, Your Honor, or responsible as.
All right. And sir asked, did anyone force, threaten, or coerce you to plead?
No, Your Honor.
Anyone promise you anything to cause you to plead?
No, Your Honor.
And you are pleading after consulting with counsel?
Yes, Your
And
Honor.
you've been satisfied with representation of counsel?
Yes, Your Honor.
As to count one, on August 21st, 2020, absconding from the House of Commons, how do you plead?
Guilty.
Sir, you understood as part of this agreement that you needed to attend substance abuse treatment. I had recommended, I think I put Red Cedar, maybe somebody, I don't remember, from 6 years ago. I've done thousands of cases since. But I did order continue to attend substance abuse treatment and provide verification of attendance. At that time, I wrote a note to myself about Red Cedar. It's possible that there wasn't a bed or that there was an agreement to House of Commons, which is fine with me because I usually say, or when a bed becomes available. So you understood clearly that you were to complete treatment, correct?
I did, Your Honor.
And did you ever enter Red Cedar?
Not Red Cedar. I went to other ones while I was absconding, but not Red Cedar.
Okay, while you were absconding, but what about, did you entered House of Commons then?
No, I turned myself into House of Commons before I saw you. He had me arrested.
I got that.
But
I'm
no, I
talking
didn't.
about, sir, I gotta do this in order, and then we're gonna talk about all the other things you wanna tell me.
Okay.
Happy to listen, but right now, did you, after I put you on probation, enter the House of Commons?
I walked in for a very short time.
And then you walked out?
Correct.
So you did not attend and participate.
Correct, Your Honor.
Okay. Based on that acknowledgement, I find that you are guilty of violating probation and I don't think it's disputed in this record or from you that you violated probation. So based on preponderance of the evidence, you are guilty. Maybe going to sentencing.
If Your Honor would so.
First of all, before I turn to Ms. Farr, have you talked with her?
I'm sorry.
Have either one of you talked with Ms. Farr, the probation agent, this matter now?
My understanding, his probation agent is actually Leanne Brown, Your Honor.
I don't know. You know what? In 6 years, there has been so much transition. I don't know. Have you talked to that agent?
She emailed me, Your Honor. We had some cursory conversations, but nothing in substance.
Okay. Ms. Farr, was he able to complete anything while on probation?
Your Honor, just so the court is aware, Ms. Brown had a death in the family, so that's why she's not here
That's
today,
fine.
and I was.
Appreciate you standing in.
Yes, of course. 6 years ago, he completed more cognitive therapy. He did not complete residential or outpatient substance abuse treatment. So he only completed MRT.
And then what about, I have 2 jail days. Do you know if he ever paid back, was it a restitution? This is so old, I'm looking at my notes. Looks like it was just probation oversight and the regular cost, but there was no restitution, is that right?
I believe so, Your Honor, that's correct.
Okay,
And this would be his second violation of probation, as the court may be aware. On July 30th of 2020, that's when he was ordered to 365 days jail with credit for 12 days served at that time, at which point the jail was going to be suspended for him to enter House of Commons, now known as Cedar Roots, and he failed to do so. I have more to say, so whenever you're ready for me to give
so
my-
he has 12 days jail?
As of today's date, since being placed into custody on June 25th and released on July 7th, he has a total 45 days jail credit, Your Honor.
And so, okay. All right, what else would you like me to know before I turn to counsel?
Thank you, Your Honor. So since he absconded, so I've read the letters, he may not be mine, but I've read the letters that we've received from the court from him, and I believe a recovery coach that he's working with. He's been gone for quite an amount of time. So I understand that he has stable housing now, he has employment, he has gotten his real estate license. In quote, "I never ran from this. I was home in Lansing." But I've seen that so many times, and I just cannot understand the thought process behind that. If you were here and you were doing well, then let's get this matter taken care of, turn yourself in and get going, not when you're arrested. And now you want to bring all this positive stuff in front of the court. So I don't understand the thought process behind that. He has a significant history with the use of drugs and alcohol. He was, positively speaking, he was tested at Aberhall on July 9th. He was positive for benzos. I don't know if he has a prescription. He did not provide that to Ms. Brown. I'm assuming he does. His test on July 13th was negative. But Your Honor held that jail in abeyance. He's been gone for so long. If he truly is doing this well in the community, revoke probation. I will leave it up to the court with the amount of jail ordered. Again, 365 days was held in abeyance.
So are there new charges? Do you know, or do people know?
There are none in our system, Your Honor.
Not that I'm aware, Your Honor, no. It was just a probation violation that he was picked up on.
All right, thank you. Counsel, what would you like me to know?
Thank you, Your Honor. Well, I mean, probation has kind of sketched what exactly I was going to tell Your Honor. It's just on a different perspective. Yes, my client recognizes that he ran. He tells me that he got messed up when, COVID came around and he did some silly things. He fell off the wagon and he ran from it. There is no argument to that. Obviously, there is no way of squaring that. The question comes down to, what did he do afterwards? Well, he's done well. He's got his real estate license. He's got a job. He tested positive, he tested negative just recently. He's trying to do the right thing. He just didn't do it the right way is. So obviously he didn't do the right thing. He's just asking Your Honor for leniency here. The way I framed this case when I was thinking about it is, are we punishing the same person that was before Your Honor in 2020 when they absconded? And the answer is not really. I mean, it's the same person, but it's a different person than he was then. When he was in 2020, he was on drugs. And when he relapsed and he absconded, he was on drugs. Today, he is not. Today, he's clean. Today, he is trying to do his best, Your Honor, and he has to make amends for the fact is what he did in the past. Are the good things that he's doing now, did that make up for it? Absolutely not. It doesn't wash away the fact is that there are some things he has to answer for. But at the same time, we just hope Your Honor takes into consideration that he is trying to do the right thing now. He could have ran from this hearing. He didn't. Your Honor graciously gave him an adjournment. This case was supposed to be heard yesterday. However, he had a dental appointment that he could have availed himself to. He did avail himself to. I'm told that it was more complicated than what they thought, and they're trying to give him a rescheduled point. But at the very, I mean, the point I want to kind of hit home here, Your Honor, is he's no longer running from this. And yes, he does have to answer for that. Yes, he's in front of Your Honor to do so. We just ask Your Honor to give him some grace, understanding that he's done some good things, and just take that in consideration during your sentencing.
So what's the relationship with your grandmother? She was the victim, wasn't she?
Yeah, the case started her. The relationship is she lives down south now. I don't speak to her as much as I used to. We were real close when she lived up here, but now she's really far away. But as far as the case, everything's fine. I'm talked to her. It was a loan. She showed up for sentencing to say that. That's why they dropped it to one count of attempted uttering and publishing. In reality, the loan was more than one check. So, yeah.
And it says that you were addicted to and abused Vicodin, Oxycontin, heroin, all of that. So the medication that you're taking now, is that for your back pain? Do you have a prescription?
It's Subutex for opiate addiction. It's MAT therapy. You heard of that? MAT. I finally got on it. I had
How long have you been on that?
since the 24th of June. I actually got the Subutex in jail. I have an allergy to naloxone. So all these times I went in and out of rehab while I was absconding, I couldn't take any MAT. Everybody else had MAT, but I didn't. And I wasn't able to complete the programs. And it just so happened, when I went to jail, they had the medication I was seeking out here the whole time, Subutex. There's no naloxone in it, so I could take it. And
That's
so,
why you show up to probation. Probation agents are really smart. They would have gotten you that help. That's why you're accountable. You know, you're in real estate. People are going to have to trust your judgment. You're going to be working with mortgage lenders and all of that. They need to trust you. You need to be accountable. What have you learned from all this?
one, I can't use drugs. And two, just like you said, I just need to be more accountable. I need to meet things head on and not put things off, because everything gets worse when you put it off.
Are you in treatment?
No,
All right, therapy? Have you
therapy,
been-
no. I just go to NA every day. I've only been out of jail a couple of weeks. But yeah, I know I need to do some brief therapy. I know I need to do some things. So as of right now, it's just NA, Your Honor.
So. How are your children doing?
They're doing great.
Would you see them, pay support, all of that?
Oh, they're not children anymore. They're grown. My
I know.
son's here in court.
But
No,
they were minors when this happened, so.
Yes.
Pay support and do what you're supposed to do, or it's their arrears?
no, I paid all support for my daughter. There's never been support for my son. And I did pay all the fines for the probation when I was on it.
Let me have people, any comment?
Your Honor, just to correct the record, I do see that there was restitution order at sentencing of $1,536 to Flagstar Bank. I'm not sure if that payment was ever made or not, but I do see that that was written, so I just want to make sure the court is aware of that.
Okay, did you pay that, sir? Were you aware of that?
Yes, Your Honor, it's paid.
Okay.
And I completed both the classes I was in. The one I think is called Pat's on Waverly,
Yeah.
and then one more I did.
All right, sir, I'm gonna give you 45 days, credit for 45 days to close this out successfully because you've done what we would have done had you stayed on probation. Sadly, you were on the run for 6 years. Was it worth it? You must have thought about this every single day.
I did.
Every time you saw a police officer, and there's a lot of them in this community, your heart had to jump.
Yeah.
Do the right things, make amends, be accountable. I don't have to do this successful, I'm only doing it because I think that you did accomplish the things that probation and I were watching. So, congratulations for that. But understand, sir, everything that happens in life happens for you, not to you. For whatever reason this happened to you, learn the lessons, be accountable, be an example to your children in this community. And, you know, help others stay free of drugs and make our community better, not worse. This, you robbing your grandmother essentially is horrible. You really owe her an apology. And I would recommend, sir, that with this gift, you give her the gift of a phone call and a thank you and an apology. She's in her 80s, she's not gonna be with us that much longer, and you owe her. Make that phone call.
All right.
What time does she go to bed? 8, 9?
No, she stays up late.
Well, before 8 o'clock today, you make that phone call. Your son is here?
Yes.
Sir, you make sure your dad calls grandma,
Yes, sir.
because otherwise, I'm not gonna be really happy.
All right.
Thank you, it's all for the record.
Thank you, Karen.
Thank you, Your Honor.
Thank you. Thank you for reading the file, Ms. Barney. I know that was a lot.
My pleasure. My apologies about the restitution.
That's not a problem. I didn't have it either. I don't know why. That might have been one of those where they added later
Yeah.
because they didn't know. And usually I write it down, so I suspect that's what happened. It was 6 years ago. I don't know.
Right.
You moved to another civil ordinance since Trinity was not here. Or I saw her come in.
She's downstairs talking to the defendants right now.
So,
What are we doing now?
Civil.
Wheeler,
Cummings.
Which one?
Do we have
Wheeler.
Cummings?
page 2, third one down.
Do we have this one, Cummings? Yeah. Cummings versus, capital internal medicine.
Yeah.
All right. This is docket 22326 CZ. Jeanette Cummings versus Capital Internal Medicine PC, Eileen Wheeler Geo, and Deborah Wagemaker, jointly and severally. Counsel, your appearances for the record.
Good morning, Your Honor. Gina Goldfried for the plaintiff. Jeanette.
Sorry, we usually do civil and criminal separate, so if you guys can share the table, that'd be great. Just mismatched today.
Sure, Your Honor. Good morning, Tim Darvis on behalf of the defendants.
Thank you. And this is defendant's motion for summary disposition pursuant to MCR 2.116 C8 and C10. Counsel, you may proceed when you are ready.
Good morning, Your Honor. Thank you. As you pointed out, this is defendant's motion or C8 to C10. There was another motion, it was a plaintiff's motion relative to the first count of the Persons with Disabilities Civil Rights Act. I guess we'll start with mine and.
Okay, well, we can take that order. I just have that just was on top, sorry.
Well, Your Honor, I filed mine and we were gonna have it in March, so we may as well start with mine. I suppose if Your Honor feels strongly enough about mine, we won't get to theirs anyway.
Okay.
So, Your Honor, this lawsuit has 5 counts. And I think there was a whole lot of background to this, and I'm not gonna take the court's time with the drama and the extra stuff because it's meaningless. I wanna keep this as most focused on the legality of all of this as possible, okay? We have 5 counts. One of them is an alleged violation of the Persons with Disabilities Civil Rights Act. That's number 1. Number 2 is intentional infliction of emotional distress. Number 3 is promissory estoppel. Number 4 is negligence. And number 5 is a violation of HIPAA, the federal law, HIPAA. And the background is essentially this: during COVID, April 15th of 2020 and June 12th of 2020, plaintiff alleges that there was a promise made to her that she could pick up her prescriptions for a controlled substance outside the building, outside of the building of SEMA, so that she wouldn't have to come through the lobby. Now, as your honor may recall, in order to pick up a prescription for a controlled substance, there needs to be, at that time, they couldn't do it through email, couldn't just send it like a script, like antibiotics. It had to be a signed document. Okay, so that's the procedure for all controlled substances in the state of Michigan at that time.
With ID, et cetera, et cetera.
Yes,
There's a
yes.
whole lot of layers there.
Yes, your honor. So in order to obtain the script for controlled substance, there needed to be that transaction so that she could get the medicine. The allegation is that in April and in June of 2020, that she had a fear of going inside the building, and she asked her doctor to get the medicine outside the building instead of inside the building. The record shows, her affidavit shows, her pleadings show, her testimony shows.
You refer to her, is that the plaintiff?
Yes, yes, your honor. Plaintiff. She got her prescription outside the building on April 15th, 2020, and she got her prescription outside the building on June 12th, 2020. There's no genuine issue of material fact. It's not in dispute. She testified about it. It's in her affidavit. It's even in her pleadings, hence the C8 part of this. And the C10, because all the discovery we've done establishes that. So all of these, count 1, count 2, count 3, count 4, are all rendered legally inapposite.
Legally what?
Inapposite, legally void, basically. Okay, the punchline here is she got the thing that she went there to get. Now, she didn't get it in the way she wanted it. Okay, so in other words, she says, well, I had to ask more than once. I had to tell you on the phone that this is how I want it. She has an issue about the original on April 14th. Basically, the issue was she called, bring me my script outside. The people inside said, well, we don't run, we're saying on A&W, we're not running stuff out to you. You got to come in and sign for it. She said, no, my doctor promised me that I can have it this way. All right, well, then these are the facty parts of this that frankly, I don't think matter, because at the end of the day, in terms of causation, in terms of damage, in terms of the actual requirements under the Persons with Disabilities Civil Rights Act, she has to be denied services. She was never denied that service. She didn't get it, I think in the reply brief to, I think, plaintiff's motion. So we've got a lot of briefs here, Your Honor. I appreciate your tolerance with looking through all this stuff, because there's a lot of stuff.
A lot.
But none of that changes the reality that when if we're talking about accommodating someone with a disability, let's just go down the line. First of all, fear of COVID is not a disability.
Right.
Okay, that's number 1. Number 2, even if it is, there is testimony that she was offered options. Come to the table, send someone else, the significant other, in with his driver's license. He'll pick it up, he'll bring it to you. So these are accommodations that we say she was given. She says there's nothing in any of her testimony or affidavits that deny that she was given these opportunities. She just didn't like the way it was going to be delivered to her. But the end of the story is the same on April 15th and on June 12th. She got the script she came there to get. Therefore, she was not denied services, period. End of story, nothing more to talk about. whether somebody yelled, whether someone didn't yell, whether it was a yell or an aggravated whisper, whether it was how many decibels was it? Could she really hear someone yell? I mean, the facts get overwhelming and avalanche. Again, they don't matter because the law says you have to be denied the service. I saw in one of the motions, or pardon me, one of the written submissions to Your Honor that, yeah, but she has to enjoy them. The word enjoyment was in, a bold, and I just thought to myself, if enjoyment of a service was required, if everybody who wasn't enjoying their service was allowed a Persons with Disability Civil Rights Act, you'd be busy, there'd be nobody, there'd be standing room only in here, every day, all day. Every one of the other claims falls with the reality that as a matter of reality, of fact, of law, she got the script, she came there both times. There's no doubt about that, can't be argued. So, as it relates to the Persons with Disability Civil Rights Act, and so let's work through that even more. There's no evidence that her condition prevented her from receiving the medical care, only that she preferred a specific method of delivery. And as I've said 12 times, if I've said it once, she got it. She got the scripts outside the building.
Which I have to say is unusual, especially for those drugs. I think most doctors would be fearful of losing their license by giving out, even during COVID, medicine outside a building into a car looking like a drug deal. I mean, that's, I think, a huge problem on whole other levels, but I mean, during COVID, lots of things happened. That's how we ended up with Zoom court, so
Well,
we're good.
And Your Honor, I want to emphasize something because you brought it right back. There's so many things that were happening amid
Right.
COVID, during COVID, that were changing daily, hourly. These are healthcare providers trying to provide a service, and they in fact did provide that service. And now it's the center of a lawsuit that we've had on the books in the court since 2022. This was originally Judge Jamo, again,
Right.
again,
Yeah, we
procedural
did the
posture.
switcheroo and believe
Yeah.
us, nobody's happy with it. I'm sorry that you all have to deal with 2 or 3 judges.
Not at all, Your
Yeah.
Honor, these things happen.
Yeah.
But that is why, when we came back, when it was reassigned to Your Honor from Judge Jamo, I asked to amend the affirmative defenses, which Your Honor allowed, and I threw in the COVID immunity, because these events, right between the uprights of COVID, the COVID immunity. So in terms of moving through here, the intentional infliction of emotional distress, there isn't any extreme or outrageous conduct even planned, okay? Even if there were, which there's not, again, she got the meds, so there's no causation, that's all. Moving through to ordinary negligence, promissory estoppel, miss that. The facts of whether she was promised it outside the building or promised it at the table without having to go into the lobby versus through the lobby versus whether it's 10 steps or 12 steps or a half inch, none of that is factually important. It creates all these fact issues, but again, legally, they're meaningless. Whether there was a promise, or whether the promise, I put in statute of frauds, I don't think there's any evidence that there's, this promise has been put into indelible ink anywhere. Maybe it was a misunderstanding of a promise. Don't know, don't care, because that's a fact that we really don't need to get into. Why? Because she got the scripts. She got them on the 15th, she got them on the 12th. There is nothing here. Negligence. Duty. Well, of course, there's no duty to go curbside. And also, this is a delivery of healthcare. So and as it relates to Dr. Wheeler, who is also a defendant in this case, there's no allegation of medical malpractice.
There's what? Not an issue?
There's no issue. There's no allegation, rather, of medical malpractice. In other words, the notice of intent wasn't served, the complaint was an affidavit wasn't served. If you're going to sue Dr. Wheeler for alleged negligence, it's got to be under malpractice statutes, which we're not following here.
And there was no emergent situation.
I'm sorry.
There's no emergent situation. There was no emergency in the parking lot where.
No, correct. However, and it didn't become one, thankfully, either. But so there's no duty, there's no breach, and the breach is because she got the meds. She got the script. She got the script exactly, maybe not with the, enjoyment that she wanted it, but she got it. Same thing with causation. She can't establish causation because she got the script she was there to get. And then damages, I mean, again, they all flow from one another. I gotta throw in the Bryant versus Oak Point case only because it's clearly, as it relates to Dr. Wheeler, it would be a medical malpractice allegation, not an ordinary negligence allegation. And they didn't do that, so as to Dr. Wheeler, at least, that's gotta go. But I submit that as to SEMA itself and Ms. Wagemaker, I'm sorry, SEMA is the Capital Internal Medicine Associates, the corporate defendant, that the employee of SEMA had no duty to bring it curbside, had no duty to even bring it outside. But guess what? She did. She didn't like it. The plaintiff didn't like how she got it, but she got it. Same thing happened again on June 12th. She got it. Plaintiff also claims that there was a retaliation by discharging the patient, and that's retaliation for the violation of the Persons with Disabilities Civil Rights Act. I submit to your honor, if there is no violation of that act, you can't retaliate for a violation that never occurred. So that is also, we can get into facts about whether she yelled or didn't yell, or whether the employee of SEMA felt verbally abused versus just another day at the office when people are upset about, COVID and stressed out during that time frame. Don't know, and it, again, for purposes of this motion, it doesn't matter because legally she got the script she came there to get. Last item here was the violation of HIPAA. The plaintiff has alleged that she asked for Dr. Wheeler to remove the letter from her records about the patient being verbally abusive to staff because the plaintiff says I wasn't verbally abusive to staff. So this is another facty thing. As your honor probably is well aware, a physician is not an indentured servant. A physician can discharge a patient from practice for pretty much any reason, as long as it's not a discriminatory reason. And the basis of the dismissal, based on the record, is that the patient yelled at staff during this interaction, or during both of these interactions in April and in June, after which, by the way, hate to beat a dead horse, she got the script she came to get. And plaintiff claims, well, plaintiff wanted the doctor to remove the reference to that from her medical record. And they didn't, because it's true. You're not under any obligation to change a medical record just because a patient disagrees with what's in it. And furthermore, in my reply brief, there is no civil damages remedy for a violation of HIPAA. That's a federal statute. It doesn't belong in front of your honor. So HIPAA, the HIPAA claim also should be dismissed. So I don't think I need to say much more than this. I would ask that our motion for summary disposition under C8 and C10 be granted in its entirety, and that this case be dismissed with prejudice. And unless your honor has any questions, I don't have any.
I may after I hear from plaintiff. Let me hear from plaintiff. Thank you very much.
Thank you.
Counsel?
Your Honor, I'm also getting situated. We did have a bit of briefing.
It's okay.
So just to reframe a little bit of what's going on here. So plaintiff had brought this as a PWDCRA claim, and I'm going to use
You need to go slower, ma'am. You
Yes.
sound to me like you're a fast talker. It's not gonna wash here.
I can slow down.
Thank you.
A PWDCRA claim, that'll be the count one for plaintiff. And now I understand there's obviously 5 counts, but I'm starting here because I believe it frames what exactly went on here. This is not a medical malpractice case. We did not raise a medical malpractice claim. I want to start with the PWDCRA. So contrary to what defendant's counsel has mentioned, the statute does use the term enjoyment, and it does not use the phrase denied services. That's what he had repeatedly brought up in his briefing, repeatedly brought up during his initial presentation of arguments. What the PWDCRA says under MCL 37.1302 is that a healthcare facility or place of a public accommodation, which SEMA is under the statute, that they are prohibited from, quote, denying, and I'm saying denying because the word is actually deny here, but denying, quote, an individual the full and equal enjoyment of the goods, services, facilities, privileges, advantages, and accommodations of
Privileges and what?
privileges, advantages, and accommodations of that facility. So I have that included in my responsive brief on page 7. That is the language of the statute. And to paint a picture, and I apologize, I think I brought this up in my reply brief, but I think it's an important illustration. So in terms of somebody with a disability, and it may be more easy or easier, I'm sorry, to visualize, if there's somebody who has an obvious physical accommodation that they need, let's say somebody in a wheelchair, the PWDCRA protects that person from being berated. They couldn't be pushed or physically abused, but then ultimately given an accommodation such as using a walking ramp. That would be a clear violation of the statute, and that would be essentially what the defendants are seeking here. Defendants are arguing that because she was not denied the ultimate accommodation, she cannot bring a claim under the PWDCRA. That would prohibit somebody, for example, in a wheelchair who had been, let's say, beaten with a cane as they were attempting to use a wheelchair ramp, and because they were able to survive the attack and go up that ramp, they could not sue under the PWDCRA. It's an extreme circumstance, but it's important that I illustrate the absurdity with which the defendant's argument, the absurd outcome that the defendant's argument would result in. So this case is unique, it is different, and it is a PWDCRA claim. It is not a medical malpractice claim. We do not claim to bring it under that statute. That is why there is ordinary negligence asserted here. So in this circumstance, there is actually a right to enjoy the services that are provided by that public accommodation. And that is what Ms. Cummings has brought her case under. She was denied the full and equal enjoyment of those goods, services, privileges, accommodations that were to be provided to her as a patient at SEMA. Now, I'm just going down this list, but to clarify one point that was made, the prescription pickup outside of the facility, that was just a piece of paper. She was not picking up a controlled substance pill or anything like that. This is not, the physician being asked to bend the rules, bend the law just to give her the paper prescription so that she could go get it filled. That's what need to happen. There need to be a signature. And frankly, to offer her partner or somebody else in her family to expose themselves and potentially contract COVID, a member of her household, it would result in the same outcome if that was the accommodation offered. But I think the key here is that whether or not she received the prescription pickup at the end, was she denied the full and equal enjoyment of being able to use that healthcare facility? Now, in her complaint, Ms. Cummings has stated, and in her deposition, she stated that she was berated, she was yelled at, the staff said she wasn't special, they're not gonna bring her out these prescriptions. She had to call and go through several different people to ultimately get her prescription paperwork handed to her outside the building, despite Dr. Wheeler promising and including in a note in Ms. Cummings' medical file that they had agreed to bring the prescription out because she was concerned about her comorbidities and she was concerned that being exposed to COVID would potentially result in death. And I think at that point,
But they
the
did
whole
eventually comply with what the doctor said, right? She got her medication.
she received the paper prescription, and that is not disputed. The issue though is that the PWDCRA does not, it mandates that she get the full and equal enjoyment of the goods and services, not that she be provided the service. So that's the key issue here. So I cited to a case.
Let me just ask you, so
Yes.
these people were not, it's COVID, everyone's overworked, especially healthcare, all this is going on, they have to now walk this tour, I can visualize exactly what happened. What are her damages from them not exactly smiling and saying, here you go?
Well, it goes beyond that. So because she was denied the services twice, yelled at, berated, the second time.
Wait a minute, she got the services, she got the
I'm
2
sorry.
prescriptions, you're
She
saying
received the
she was denied?
I'm sorry, I misspoke and I was speaking too fast.
Yes.
She received her prescription, but in both occasions, she was yelled at, berated, told not to come in, and verbally abused by a staff member.
Okay, so
So when,
the doctor's also saying that the doctor released her because she was the abusive one. So we have 2 sides claiming abuse, and the doctor can't be held, just like you, counsel, can't be held to keep a client who yells at you. When I was in practice, I had a client who yelled at me after I did a good job in front of Judge Collette and got what they wanted, all that I could get, and he yelled at me in the hallway, and I said, and I'm no longer your counsel. He then tried to sue me, which was dismissed, but that kind of stuff happens to counsel, it happens to doctors. I mean, we don't have to keep clients who berate us, do we? Are you suggesting the doctor has to keep her?
well, a couple things there. The complaint is to be interpreted in a light most favorable to.
I
sorry.
understand my job, I need to know where you're coming from in terms of the realities of this. I have to look at this in the light most favorable to the non-moving party, I get that. But I'm trying to understand if your client has an actual claim, or if she's just angry that the doctor fired her as a patient.
Well, she does have an actual claim. She did not allege that she berated them. She alleged that she was berated. There is no evidence besides her own self-serving testimony that Ms. Cummings would have berated them. And frankly, Ms. Cummings she was not at all in a position to yell at them. That's just not her personality. That doesn't matter necessarily, but my point is, she raised the claim that they berated her. She did not say that she berated them. There is no.
Well, why did she raise that? They raised that, and that she's
Correct.
unhappy, because the doctor essentially said, you're no longer my patient.
And well, Ms. Cummings disputes that she berated them, but also the report that she made the second time came 3 days before she was discharged. Nothing else happened in between that. Her complaint was, and this is what's in her legal complaint as well, but the report that she made about being berated on the second time resulted in them discharging her as a patient. She has alleged that they had included that she did what they actually did only to create a written basis in order to get her out of the out as a patient at SEMA. That was what she alleged in her complaint. That's what she stated in her deposition testimony, and that's what we've raised in the briefs. Again, that is taken in on her side to be what has happened here. Now, if there's a dispute of fact, I think that's one question, but she made the report, and within 3 days, a temporal proximity matters. She, and I believe her partner, made 2 written complaints about the interaction between one of the SEMA agents and Mrs. Cummings. That proximity and that fact that no one is supporting the self-serving testimony of the doctor and Ms. Wagemaker, that they supposedly that our client yelled at them, no one else is supporting that. She's presented evidence to the contrary, that it was them who had yelled at her, and she has a witness that can testify to that as well. So the fact that the report came 3 days after that and blames her for the exact conduct she reported makes it at least at a minimum a question of fact to go forward that that action that they took was in retaliation for her making her report that was protected under the PWDCRA. I'm sorry, that was long-winded to get there, but I need to address a couple back and forth points. Or back and forth facts, I should say. I apologize, I just want to make sure I
Okay.
answered
Anything
your
else?
question.
Yeah.
So, well, to go down the list of the different things that the defendants raised. The intentional infliction of emotional distress claim. I'm not aware of any cases that they cited where she could not bring.
Oh, so that's what stopped it. The intentional infliction of emotional distress came out.
Yes, the intentional infliction of emotional distress claim. I'm not aware of any cases that the defendant cited that prohibit or preclude plaintiff from bringing her claim that she was berated, verbally assaulted, verbally abused, outside of the clinic when seeking a reasonable accommodation, or at least confirming the agreement to get that. They have provided no case law that she cannot bring an intentional infliction of emotional distress claim. We all know the eggshell skull doctrine. Ms. Cummings has complex PTSD. This is something that Dr. Wheeler as well knew profoundly about Mrs. Cummings. And she had suffered verbal, physical, all sorts of abuse from her ex-husband for a long time that makes her ability to process that type of behavior different than someone else in the community without those conditions, without those disabilities. That's a fact issue that can still go before the court. And we've, at a minimum, we've brought forth all of the factual disputes related to that. It's not that she cannot bring an intentional infliction of emotional distress claim. She can. The question is a fact issue as to whether she has proven the damages and the elements associated with that claim.
And the
So
what associated?
the element and damages associated with that claim. For promissory estoppel, we have cited, introduced into evidence through the brief and through deposition testimony that Dr. Wheeler, in a written note, promised to bring out this, or have someone bring out the prescription paperwork to her outside of the building. That was agreed upon. It was a promise. And in order to get the promise, Mrs. Cummings had to be verbally assaulted. So in terms of whether she received that promise with, without having to, essentially experience abuse is a question of fact to continue to go to the jury. I'm moving on to
But
negligence.
aren't you saying the promise was fulfilled? The alleged abuse is a separate issue, isn't it?
Well, she didn't promise, she didn't ask to be abused as part of that process.
She asked for the prescriptions, which she got.
She received the prescription paperwork, but she did not receive it without having first been abused, first been told she cannot do it. Those were not parts of the agreement, so those are not, even whether she's been given the prescription, that part of the promise is still, violated by that verbal abuse. I'm sorry if that's not clear. Do you need me to clarify a little bit more?
No.
Okay. So for negligence, again, we're not bringing a medical malpractice claim. I understand there are requirements of a notice of intent, but this does not have to do with medical treatment. It simply has to do with an accommodation. People have a right to a reasonable accommodation when they go to the store, when they go to a healthcare facility, whether it's SEMA or any other place that somebody could walk into as a member of the public. They had a duty to provide reasonable care. And they promised to provide those prescriptions to Ms. Cummings outside of the building. She did not ask for curbside service. I don't know why they keep saying curbside service, but she asked for the prescriptions to be brought outside the building and it was granted. That is not anything to do with treatment as a medical provider. So her negligence claim is valid in terms of she's not trying to bring a medical malpractice claim. They're two separate lanes. She's bringing it against WageMaker. WageMaker is not a physician. She can't even, those claims are there against both of them, but regardless, because it doesn't have to do with provision of healthcare services, just simply bringing the paperwork out, there is no medical malpractice claim that we are trying to bring. That's essentially a red herring. We're not making that claim, so there's no reason to point out that there's been a notice of intent filed, et cetera, et cetera. It's not a claim in this case. For HIPAA, we cited to 45 CFR 164.526A sub 4 in most case Roman numerals. That requires if a patient requests a change to their medical record, that a provider provide a written denial. A written denial did not occur. There's no dispute that a written denial did not occur. That is the basis of the HIPAA claim. That's a very simple one. That is essentially the facts for that. The COVID immunity is also a red herring because again, this doesn't have to do with providing services under the COVID Immunity Act. When you read the COVID Immunity Act, we cited to this language in our response, that has to do with healthcare services as they're providing services related to the pandemic. They're simply handing her a prescription paper. That doesn't have anything to do with treatment related to COVID. They were not giving her a vaccine. They were not treating her for a condition. They were giving, this has to do with them providing a reasonable accommodation. Again, this is a PWDCRA claim at its core, and that
So why doesn't this fall under your count one?
this is part of count one, but what
So why do
defendants
you need
are
a separate one?
I'm sorry.
Why, you've got a separate count for violation of the HIPAA, but it really falls under the PWDCRA.
Well, the HIPAA is just, it's a procedural issue. If they deny her, and if they're denying, they're saying, you know, Ms. Cummings, we're not gonna change your medical record, that has to be a written denial. That's separate from the COVID Immunity Act. What the defendants are saying is that the COVID Immunity Act would preclude any liability at all in this case, because that act supposedly, according to them, applies to any kinds of care that has been provided due to treating COVID. But there's no treatment for COVID here. And I think my point is more that the COVID immunity doesn't prevent the HIPAA claim, because this doesn't have anything to do with treatment for COVID.
Well, in fact, it does, because what your client, because of her vulnerability, was fearful that she would get COVID going into people, into the treatment room or what have you, and into the building. And so they agreed to do something unusual, which is to personally deliver outside the building these prescriptions. So it was COVID related in that regard, the fear of getting COVID, I suppose.
Yeah,
I mean, that wouldn't have
treatment.
But for COVID, that would not have happened, correct?
But that's not treatment for COVID. She would have had a right to do that if she was getting her prescription at Kroger.
Okay, but it's preventative care, isn't it?
The provision of a prescription outside of the door, it's something that SEMA and their Dr. Wheeler and Wagemaker admitted was something that they were doing at that point, and as well as administering other types of non-COVID related vaccines, for example, they were doing that outside the building. Those are accommodations, they're not necessarily treatment related to COVID. Any person in that office could have handed her that piece of paperwork. They're not provided, or they're not doctors, they're not providing the healthcare services. It has to do with an accommodation to provide that paperwork, not necessarily for anyone in that office to treat her a specific way. The prescription was already prescribed by the physician. That's not the issue. It's just about whether they got that to her without putting her in a position where she would face an undue risk of infection simply because they wouldn't walk it 2 or 3 feet out the door, which Dr. Wheeler even admitted was not unreasonable whatsoever.
It's just an accommodation due to COVID. It would not have happened other than for COVID. It would not happen today.
That's not what the Pandemic Healthcare Act covers.
Okay, but I just, okay, I understand.
Your Honor, I think that will cover at least defendant's part of these motions here.
Thank you. John?
For purposes of making a record, Your Honor, Section 302 of the Act, we're talking Persons with Disabilities Civil Rights Act, says, except where permitted by law, a person shall not, and this is subletter A, deny an individual the full and equal enjoyment of the goods, services, facilities, privileges, advantages, and accommodations of a place of public accommodation or public services because of a disability that is unrelated to the individual's ability to utilize and benefit from the goods, services, facilities, privileges, advantages, or accommodations, or because of the use by an individual of adapted devices or aids. Now, I read that into the record because, and that's on page 6 of my response to plaintiff's motion for partial summary disposition. It's also in the law, like the real law. The reason I bring that up is because it wasn't quoted in its fullness, and I think for purposes of making a record, I wanted to do that. Once again, the denial has to be of the services, and she wasn't denied the services. Okay, maybe she didn't like it, maybe she didn't enjoy the process, but she got the services. She was there to get a script for a controlled substance, and she left with the script, both times, April 15th, June 12th. That's all. So I wanted to read that into the record. The examples that she's used, this woman is not wheelchair bound. Her alleged disability is that she was afraid of getting COVID and didn't want to go inside the building. So instead, it only makes logical sense to have someone who was inside the building open a door and bring it out to her. Because, you know, somehow that going inside rather than outside changes everything, except that it doesn't, but reality must intrude. So, but she got it. That's the important part. She got it every time, both times. I don't want to get into the evidence about who yelled at who and whether it was a stressful situation, because it doesn't matter. And I would submit once again, if there's no violation of the Persons with Disabilities Civil Rights Act, then there's no retaliation for a violation that didn't happen. So whether they, the idea of self-serving testimony from either of my clients, Dr. Wheeler or Ms. Wagemaker, she said, the plaintiff's counsel says, well, self-serving testimony. Well, you know, self-serving testimony the other way, they'd say, well, you didn't yell at me, I yelled at you. Again, who yelled at who, frankly, under this scenario, under the law, it doesn't matter. It doesn't matter at all. We get to intentional infliction of emotional distress. Once again, a dispute during services doesn't rise to the level under Michigan law of intentional infliction of emotional distress. Plaintiff's counsel said, well, we can still bring it. Well, you can bring anything you want. You can bring whatever case you want, you just can't prove it. And the record now before this court establishes there is no genuine issue of material fact, that they can't meet their elements. And that's addressed in the brief, and I mentioned it too. The promissory estoppel, once again, the promise, alleged promise, was in fact delivered upon twice. So even if there was a promise, which I would submit there isn't, but frankly, it doesn't matter, because she got the object of the promise that she claims existed. Undisputed. Affidavits, testimony, pleadings. The negligence issue, same thing, no breach, because, you know, she got what she asked for. She didn't get it the way she asked for it, but she got it. The idea of it being only ordinary negligence and can't be malpractice, they say, well, this isn't about healthcare. Well, show of hands, anybody else in this courtroom, can they write a script for a controlled substance and deliver it to somebody? No? Okay, well, because that's unique to a doctor. So if you're going to sue a doctor for that, you're going to have to follow the Met-Mal under Bryant. It rises out of under Bryant, B-R-Y-A-N-T. So if you're going to sue Dr. Wheeler over that, you got to follow the statute. So, and they didn't. So whether they want to maintain it against Ms. Wagemaker and SEMA, that's a different issue. But any claims against Dr. Wheeler would have to be dismissed. Although I submit for the same reasons I've already mentioned, the negligence case has to go too for those same reasons. Meaning there is no violation and there is no cause under the record now before the court. The issue about HIPAA, as I say, there's no private right of action. So no private right of action under HIPAA in this court in front of Your Honor. Respectfully, it's a federal thing. There is no private cause of action, so that's got to go. So they can call it whatever they want, but it's not a recognized action under state law under this in this form. And then lastly, Your Honor, hit it right between the eyes. This has everything to do with the COVID timeframe, and I want to read actually the COVID Immunity Act, which is MCL 691-1475. And I know this is arduous, but I'm just making the record, Your Honor. I'm sorry.
No, it's your right to make a record, both of you, so take your time.
Thank you, Your Honor. The act provides in relevant part, and this is at page 9 of my reply, a healthcare provider or healthcare facility that provides healthcare services in support of the state's response to the COVID-19 pandemic is not liable for an injury, including death, sustained by an individual by reason of those services, regardless of how, under what circumstances, or by what cause those injuries are sustained, unless it is established that the provision of the services constituted willful misconduct, gross negligence, intentional and willful criminal misconduct, or intentional infliction of harm by the healthcare provider or healthcare facility. So in tandem, this was drafted very broadly. And in fact, it covers basically all of their claims, even the ones that they cannot, as a matter of law, establish. And I think that's all of them. So unless Your Honor has questions for me, that's all I have.
No.
Thank you.
This is certainly a unique case, and while I feel for the plaintiff, I am going to dismiss all claims with prejudice. It does not appear to me that there's anything here that rises to the level of what's been alleged. In fact, in regard to the malpractice, that would clearly have to be dismissed against the doctor. But in regard to SEMA and WageMaker, the services were provided. HIPAA does not provide a private right of action for an individual plaintiffs in state court. That would be a federal question. These certainly are unusual issues. However, in every instance, although maybe not with the kindness that should have been delivered, but under the COVID Immunity Act, accommodations were made. It is rare for any doctor, nurse, assistant, whatever label you want to put, to go to this extreme measure to provide scheduled drugs or prescriptions outside the building. And they went through extraordinary measures to accommodate this plaintiff. And I don't see where any of this rises to the level of intentional infliction of emotional distress. In terms of the promissory estoppel, the promises were kept. She got the benefit of what the doctor wrote. The doctor does not have to keep her. When it was placed in the file, I suppose I could hear that case, but the doctor doesn't have to keep a patient, and doctors do have to document everything, same as lawyers. So how and when it got in there, she didn't have to keep that patient. It was very clear that both sides were unhappy with whatever was going on between them, and they needed to split. So I don't think that in terms of count one, the discrimination and retaliation, and I think that there was a violation of the Civil Rights Act that's been proven here that can survive. And so that is, anyways, all of these are granted in defendant's favor. And for the reasons stated by defendant, I will adopt them as my own.
Your Honor, if I may, we didn't have an opportunity to argue our motion that was scheduled for today as well. And I understand that defendants, and I apologize, may I come up to the podium? Very briefly.
Yes.
I understand that there's competing motions for summary disposition. On the PWDCRA claim, however, we didn't have the opportunity to argue our part of the brief, which I understand there's overlap. However, the full, I apologize.
It's okay. Make your record. You can, I certainly make the record for the appeals court. I see that coming no matter what I rule, but so make your record, but I don't know that it's going to change my ruling, but you can try.
Thank you, Your Honor, for the opportunity. We cited to Wells versus County of Bay, and that's important because, again, as defendants even reiterated, it is the full and equal enjoyment of the public accommodation that is required. Wells versus County of Bay quotes or states directly that this connotes something more than bare access. Connotes. Something more than bare access. End quote. Again, it is more than simply providing the services, and the quote that defendants read, unless I misheard or misread, does not state that provision of these services renders the obligations fulfilled. It does not include the term provided services, as far as I can tell when I look at it, unless I missed something. But again, this connotes something more than bare access. You cannot throw a prescription at someone and just because she caught it, she's got it. This has to do.
Are you
with
suggesting they went
a
out into the parking lot and threw a prescription?
I'm not, I'm using that as an example.
I don't want you to use examples unless it's coming from the actual facts, or it comes from a case, because the picture that you just gave me is far different than what I just heard. So what I heard was that there was this disagreement about should she come in the building or have to come in the building. The staff went out of their way, gave her the prescription, wasn't exactly kind, but she got twice the prescription and it wasn't thrown at her because as it is, it probably would have flown out of the car and then we'd have a whole different issue. But she was able to receive it properly and fill it, correct? Wasn't thrown at her.
She received the services, but that's not what the statute requires. It requires full and equal enjoyment, and if they berated her, they verbally abused her, and they have a competing narrative, that's just a factual dispute, and if anything, that would render it an issue to go to trial. Obviously, on our end, we filed the motion.
Let me interrupt you there. What are the damages for someone not being exactly 100% kind to you?
It's not that we're alleging that they weren't 100% kind to her. We allege that they had abused her and that her damages stem from the fact that she made the report to the defendants about the behavior. They discharged her, left a note in her file about false behaviors that she did not commit. And then that prevented her from being able to be seen for several years based on that file that was in the SEMA record.
Wait a minute.
So that's where the damages come from.
Did you plead that she was not then able to be seen by any other doctor because of this one note? She was not denied medical care. This is news to me. She wasn't denied medical care for 6 or 7 years, was she?
Going into the complaint because she does state that she was not able to find a new doctor after that note was in place. Let's see. I'm sorry, second counts.
Okay.
Please. Okay. So for example, in 71, Ms. Cummings pleads that the defendant retaliated against plaintiff by terminating her as a client and placing a note in her file that made it harder for her to seek treatment elsewhere. That was an issue discussed at length in her deposition when, as well, just to add context, about who she tried to go see, which physicians she was or was not able to see. She talked about her history with Dr. Wheeler and having, you know.
I'm just gonna stop you there. Let me just stop you there. So she can't go to another doctor because there's this note. When I go to doctors, I say, okay, I'm referred, I'm looking, and then I have to sign something that says that my records can go to this doctor. Is there going to be testimony from any of the doctors that she consulted that that was the reason they didn't take her on? That was that one particular note? Is there any evidence of that?
Ms. Cummings couldn't get into another physician for quite some time. I don't have a trial strategy locked down, but I believe that there are witnesses in there that will testify to the fact that she was not able to get into another facility with those records for quite some time.
I deal in evidence, so I don't, I always say, take your beliefs to church, got evidence. Do you have any deposition or other testimony from other doctors that she tried to get in with that they did not take her because of this particular note in her file? Yes or no?
We don't have deposition testimony with other doctors, but we have Ms. Cummings' deposition testimony, which is evidence, as I understand as well, for the case.
Does she have particularized information specific that she was told because of this note, we cannot take you? Yes or no?
Your Honor, she testified to that in her deposition, that when she tried to get into a facility after that, she was not able to, and this note made it harder for her to do so.
how does she know that? I find it incredible that any physician's office would say she has this note, therefore she cannot be seen. That's not a reasonable assumption. Do you have any actual evidence other than the speculation of your client?
This is evidence, testimony, sworn evidence from my client, and I would be hard pressed to find a physician that would want to accept a patient that another physician claimed was verbally abusing them. I think that that would be something a jury would, that would be understandable to somebody. Ms. Cummings' testimony is what we have in the record entered so far. I don't have the witness list in front of me. So I can't confirm who her physician witnesses are that are listed on there. It was probably filed a couple years ago.
Okay. You may proceed.
Then, again, with our PWDCRA motion, I think the core point that I tried to make earlier is that the Pandemic Healthcare Immunity Act and the PWDCRA are separate. The PWDCRA applies to any public accommodation, any facility. A healthcare facility is even a term that I believe is used in the act as healthcare facility. But regardless, a healthcare facility is a place of a public accommodation. It would fall under those definitions as well. That is a requirement that is not eliminated by the pandemic. Not eliminated. Eliminated. Thank you.
But they did provide this service to her. They accommodated her by going outside the building, which I suspect she was the only patient they did that for, or very few did that for.
I believe that they had testimony that said that they did do that for other patients. And again, they provided that accommodation in other ways when, for example, providing flu shots outside during the COVID time period. That's not a COVID shot, it's a flu shot, but they brought them outside. And even Dr. Wheeler said specifically that it wasn't unreasonable to walk a few extra feet.
Okay, so she did get the services that she needed.
But she did not receive the full and equal enjoyment of the public accommodation. That is the key point that plaintiffs tried to make. And that is essentially what I wanted to reiterate within this opportunity to just clarify the record. And I won't continue wasting time. I know we're beating this point.
Yeah, and that's okay. I think that this is one of bedside manner. And there is a whole array, just like with lawyers and judges, there's a whole array of bedside manner from doctors and their staff. And I think this is something where they accommodated her medically, handled her medical issues, and she wasn't necessarily happy with their bedside manner. My ruling remains the same. If you'd like to make a further record, you may.
Very briefly, only because it was brought up about the testimony of, there may be testimony that she couldn't get in to see a doctor. That just came up today for the first time in front of Your Honor. I feel the need to put it on the record. I'm not going to argue, but I do think it's very dangerous for an attorney to come up here and make a statement that he or she should know is not accurate. So if I had her whole transcript, I would read it to Your Honor. I don't have the page, I don't have the transcript, but I can tell you in fact, as an officer of the court, because I took this deposition, that at no point did this woman testify that she couldn't see a doctor because she had no physician she could name who refused her because of this note. As a matter of fact, she testified that she didn't even give her records to other doctors because she was nervous that they wouldn't take her. Because
that was my understanding when I
So,
gleaned the record.
The transcript does not reflect what that.
Thank you.
Yes, Your
You
Honor.
present an order?
I do have an order and I will
Thank
provide
you.
it
If
to
you'd show it to counsel, please.
counsel.
I take issue with you trying to make it seem like I'm making a false statement on the record. I did read off the complaint and I wasn't part of Ms. Cummings' testimony. If there's a misstatement, I can be a grown up and agree to something like that if I have something written down and I can read it, but I don't appreciate an ethics claim.
I didn't hear an ethics problem. I think it's just one of,
It was a cautionary note of generality, Your Honor. Here's the proposed order. May I approach?
May.
Thank you. It just reads for the reasons stated on the record, Your Honor.
Any objection with this? I mean, I understand you're objecting to my ruling, and you certainly can go to the Court of Appeals. However, what he has is a pretty bland order. It does reflect what happened, and what I did is, under the paragraph that says it is so ordered that defendant's motion for summary disposition is granted for the reasons set forth on the record, and the case is dismissed with prejudice. I simply added in its entirety. So there's no question, because there are so many claims.
Thank you, Your Honor.
Your Honor, I'm not making an objection to it right now, but I will note that it doesn't include our motion, and we need to submit an order for that as well.
Yeah.
I have one for
Yeah.
that too, Your Honor.
All right, will you show it to her, please?
I will.
Please make copies.
And Your Honor, just so the record is complete, I didn't know which was gonna be listened to first or heard by Your Honor first. This one denies plaintiff's motion and grants defendant's motion under 2116I2. May I approach?
You may. Do you have an issue with this order as well?
No, I haven't got this one yet.
All right, let me know when you're ready. I heard them in reverse order, but they make sense the way they're written.
I'm not presently objecting to either.
All right, thank you. Court is signed. Well, if you just wait a moment, we'll get you all copies.
Thank you, Your Honor.
Next matter. Is Ms. Trimble still downstairs?
She's still downstairs, Your Honor.
Okay, well,
How are
not
you?
anymore.
Tringle.
Brady's waiting for copies.
If you can bring everyone up, just bring them all up.
She should be that. Can you send Ms. Tringle up?
I met with her.
Tell her thank you. She's had enough time, so. Thank you so much.
Been there for like an hour over there. And she's on all of them, right?
She's on all three, yes.
She's on all three.
Yes, he's got copies.
Thank you, Your Honor.
Oh, did she leave without her?
She left, she's, yeah.
Oh, she's good.
Can you mail, Brian, can we, or council, can you mail her copies?
I'm happy to do that.
Thank you, appreciate that. You guys wanna jump into civil? I know, right? With that attitude.
Thank you, Your Honor.
You know, thank you. You know I was happy to 100% criminal, and I do again. I think Stokes likes this stuff.
We should switch.
Huh?
I wish we would switch.
I can go, Stokes and I wanna switch back, they just won't let us.
I was a judicial law clerk for 2 years and I was having flashbacks here. I law clerked for, in Allegheny County,
Oh.
Judge Baker.
Okay. Yeah, so yeah.
So yes, very, very familiar.
So did you agree with my ruling?
Yes, very much.
She gone.
You know,
She gone.
nothing's gonna survive. Didn't know.
Judge, are you calling the
Are you on
Thompson
the-
case?
And we're waiting for the attorney to come upstairs. Are you on the Thompson matter?
I am, Your Honor.
All right, thank you.
I'll be ready when you are.
It'll just be, we're just waiting, I've been waiting for counsel for the last hour, as have you. I apologize for the delay.
We could probably, is Miss Callahan here in the court? I want to say we do that set aside.
No Meta Callahan?
Miss Callahan, are you on Zoom?
Thompson.
Yes,
Yeah.
Thompson.
I think Miss Callahan is on Zoom, so after this, we can do that set aside.
Great.
I don't know. Here's the set aside.
Let me see if she can have medical record. Against the
I just, Ms. Pringle actually. Just waiting for your attorney, sir, just.
I've got that RB. I just want to say. Right. I wish I would. I might.
I'm surprised I haven't been held in contempt before, honestly.
Yeah.
I had a couple of attorneys.
I might have to hold her in contempt. All right, thank you very much.
Like, do you?
She's in court twice.
We want to do the set aside? Okay.
Sure.
Sorry.
So just have a seat there.
Oh, okay.
No one else is coming in. I think they're all in.
The set aside.
We're doing no Meta Callahan.
All right.
Wait,
this- Yeah, we're gonna do the set aside. All right, this is docket 91-62603 FH, 11-965 FH, and 17-1061 FH. People of the state of Michigan versus Nomadic Callahan. Counsel, your appearances for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Good morning, Your Honor. Rebecca Nybert serving on behalf of Legal Services of South Central Michigan and Mrs. Nomadic Callahan. Ms. Callahan, can you state your name for the record?
No, please stay, raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes,
And you are the defendant in this matter, Nomadic Callahan?
yes, Judge, I am.
Thank you. And on behalf of the people, have you received all of the necessary paperwork?
I have
Yes.
received the letter from the Attorney General, Your Honor.
All right. And is there any objection?
The concern that the Attorney General brings up is Ms. Callahan's 2012 conviction of the reckless driving that may be ineligible to be set aside. Specifically, I believe in this case, Your Honor, a traffic offense that causes injury or death is also ineligible under the statute. I am going over this real quickly. It appears that in this incident, Your Honor, it did involve Ms. Callahan potentially hitting an individual with her vehicle. It does look as though they were taken to Sparrow Emergency for back pain, abrasion on their right foot. So it does appear that there were injuries here. So I think under the statute, under MCL 780.621C, subsection 1, subsection D, subsection 3I, I do believe that she would be ineligible for the reckless setting.
Response?
Yes, Your Honor, we believe it was more of a death or dismemberment argument of whether it related to being an accident that had injury. And here we don't have a death or dismemberment. And so we don't believe that the driving reckless should be denied.
So read that statute to me? I don't have it in front of me.
Yep, let me pull it up, Your Honor.
Yeah,
And I apologize, I'm going off of what the Attorney General letter said. Let me pull up the
Yeah.
statute proper. Yeah, I'll see behind you.
Thank you.
so does it just say injury, or is there a comma, or does it say death?
And let me pull up the exact statute, Your Honor.
Yeah.
Give me one moment. I am seeing, Your Honor, it's specifically on at MCL 780.621C, prohibition on setting aside convictions for certain criminal cases. A person shall not apply to have set aside, and a judge shall not set aside a conviction for any of the following. And then subsection B, the following traffic offenses. And 3I says any traffic offense that causes injury or death.
Okay, so the driving reckless cannot be, if it's injury, if there was an injury, then, and if you want to move this out a couple of weeks to research the specific facts, I don't have a problem with that, but according to that, it looks like I cannot do the reckless driving, I can do the others, however. What would you like?
Your Honor,
Kathy?
could you rule on the other, what, 3?
Yes.
And then I will look into the other one.
Okay, and the other thing I need to know is, it says an application is set aside the following convictions was filed on, what was the date of your filing? It's not listed in the proposed order.
Yes, Your Honor, because we actually sent it in the mail, so I wasn't sure when you actually received it. So that's why I didn't put it in the order.
Oh, when did you put it in the mail? It's under the mailbox rule that counts, right? So do you know when you put it in?
Okay. Yes, Your Honor, 1 second, please. It was sent in, sorry, 7/8 of 26.
Okay, thank you. All right, thank you. So what I have done, council, is I have simply on the order whited out your proposed C, and then I suspect that that would go under the same transaction perhaps, because there's 4 here. I don't know, we'll figure that out at when you come back, but I'm certainly happy to hold that one in abeyance. You can refile whatever it is you need, and then we'll proceed on A, B, and D. Is that acceptable?
And you said, I'm sorry, what date was that?
Under the charge codes, you've got the crimes listed: assault with dangerous weapon, domestic violence, aggravated malicious destruction. You've got them listed A, B, C, D. I've simply whited out C, and then, which is the reckless driving. We'll proceed on A, B, and D. And I'm whiting out the reckless. Okay, just want to make sure you see, we make a record of why there's some gaps here, but we're good. All right, thank you. So, ma'am, what have you learned from this?
Yes, I have learned to, I've changed a lot. For the first and most of all, I dedicated my life to the Lord. I take accountability for every action, every bad choice, every bad mistake or what have you. I've learned I am a better person. I am a better woman. Also, Your Honor, I am about to receive my license to be a counselor, to counsel hurt and abused women. I also have known of young teenagers try to encourage, so that they won't make the same choices or the bad mistakes of my younger years that I have made. And so, Your Honor, I'm just a better person. I work in my church. I'm training to be a Sunday school teacher for third and fourth graders. I'm a greeter in my church. Through our district and our conferences, I volunteer to do what I can to help. And so, Your Honor, I'm really doing productive things in my life right now, and I'm looking to forward to do even better and to make a difference. To help anyone that I can, to encourage anyone that I can. And I'm just trying, Your Honor, right now to be the best that I can be.
All right. Counsel, did you have anything to add to that?
No, thank you, Your Honor. She did a great job.
All right. And yes, she did. In regard to the people, once we've made that correction and we'll revisit that other issue, you have no issue or argument with proceeding to grant the set aside as to the other 3 counts. Is that correct?
That is correct, Your Honor. She seems to be eligible under the statute for the
All
rest.
right, thank you. An application to set aside the following convictions was filed on July 8th, 2026. Assault with a dangerous weapon, domestic violence, aggravated malicious destruction of property, $1,000 or more, but less than $20,000. The court finds the Michigan State Police has reported the required information from its records to the court. The applicant has not been convicted of more than 3 felonies. The applicant has not been convicted of any criminal offense during the applicable time period required pursuant to this statute. There are no criminal charges pending against the applicant. And the applicant has had no convictions for an assault of crime set aside pursuant to the statute during their lifetime. The applicant is requesting that a felony offense punishable by more than 10 years imprisonment be set aside. The applicant has not previously had a felony conviction for the same offense set aside pursuant to the statute. And the time period required by the statute for all convictions listed in item 1 has passed. And an opportunity has been given to the Attorney General and prosecuting official and state police to contest the application, and no one has. Circumstances and behavior of the applicant from the date of the applicant's conviction to the filing of the application more than warrant and justify setting aside the conviction, and it is consistent with justice and public welfare. Therefore, the application is granted as to the convictions listed in item 1. And pursuant to the statute, the Michigan State Police shall maintain a non-public record of the order setting aside conviction and of the arrest, fingerprints, conviction, and sentence of the applicant in each case to which this order applies. If the conviction was for an offense that was reportable to the Secretary of State in accordance with the statute, the driving record would not be expunged. If the court or arresting agency maintains a record of the arrest, biometric data, conviction, or sentence, that record shall be non-public and not used for any purpose unless authorized by law. This has been dated, signed, and read in open court, and it is ready for entry. Ma'am, if you were here, I would be asking you to approach and shaking your hand, congratulating you, and handing you your document. But I can't do that because you're on Zoom, so we're going to make sure the clerk enters it here. Now, counsel, if you and your client find it's not been taken care of in like 4 weeks, please let me know so I can make a phone call on your client's behalf. And then if you need to come back in regard to the other matter, what we can do is check the box that it's the same occurrence. I think it might be from the one file. I leave it up to you to look at. But anyways, ma'am, the last order of this court is to take your loved ones out to a celebratory dinner no later than this weekend. Good luck to you, ma'am, and thank you for your good work.
Yeah, I just want to say thank you so very much. Thank you.
Well, thank you. You know, you're an example to the community because people make mistakes, but it's those teachable moments and things happen for you, not to you. And certainly these things happen, but in regard to your life is so much better now. You've made our community better and now you're helping young people. And I don't know what more we could ask of you. So congratulations. Have that dinner with your loved ones. Thank you.
Thank you. I appreciate you. God bless.
Thank you, Your Honor.
Thank you. All right, now we are on docket 18-1059 FH, People of the State of Michigan versus Ralph Frederick Thompson. Counsel, your appearances for the record.
Good afternoon, Your Honor. I'm Special Assistant Attorney General Mitchell Wood for the people.
Good afternoon, Your Honor. Please come up to the podium.
Good afternoon, Your Honor. Amanda Tringle, Office of the Public Defender, appearing on behalf of Mr. Ralph Thompson, who's present to my left. To my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide me the truth, whole truth, and nothing but the truth under penalty of perjury?
Yeah, sure.
Thank you. And sir, have you taken any medication yesterday or today?
No, yeah.
Are you supposed to be on medication you're not on?
No, yeah.
Any sign of fever, COVID, or other illness?
No, yeah.
And you had no time to speak with your attorney?
Yes, sir.
You were placed on probation after being found guilty by a jury of failure to pay child support punishable by 4 years. And that was on February 21st, 2020. The sentencing date was December 2nd, 2021.
Right.
You recall that?
Yes, sir.
All right. And now I believe I placed you on 48 months of probation. And now I have a probation violation that is in this bench warrant that was signed by this court on February 2nd, 2026. And it states count 1, on or about January 13, 2026, defendant failed to report to probation as instructed or any time thereafter. And Ms. Farr, is that the only violation? I suspect he also failed to pay child support.
That is correct, Your Honor. I, again, am covering for Agent Meisling on this one. But that is the only one that I showed. So we could verbally add a count 2.
So count 2 is where the added defendant failed to pay child support as directed. Any objection to that, Ms. Tringle?
No objection, although we would at some point request a written copy of that, please.
You can get a copy right now.
Thank you.
And are you waiting for further arraignment?
Yes, Your Honor.
And will this be a plea or a hearing?
This will be a plea.
Is that correct, sir?
Yes, sir.
Did anyone force, threaten, or coerce you to plead?
No, yeah.
Anyone promise you anything that caused you to plead?
No, yeah.
And you decided to plead after you spoke with your attorney?
Yes, sir.
And you've been satisfied with her representation?
Yes, sir.
All right, and one moment. We can give a copy.
Thank you.
So I don't have mine, but I will have it in just a moment. Thank you. And sir, as to count 1, on or about January 13, 2026, failure to report to probation as instructed or any time thereafter, how do you plead?
Guilty, Your Honor.
As to count 2, failure to pay child support as directed, how do you plead?
Guilty, Your Honor.
And sir, you understood the terms and conditions of probation?
Yes, sir.
And you understood you needed to report to probation each and every time and regularly pay child support. And at that time, I noted you had an arrearage of $28,016. I don't know what it is today, but you were well aware that you owed that. And I also ordered a wage assignment.
Can I say something now?
You're in a moment. You understood all.
Yes, sir. Yes.
All right. I find defendant's plea to be appropriate and I also find that his plea was voluntarily made, freely understanding, without undue influence, threats, promises of leniency. There are sufficient grounds based on his acknowledgement, and therefore count 1 and 2 will enter. I will let you address the court in just a moment. On behalf of probation, what is the recommendation? And do you know the arrearage, or shall I turn to the, do you know the arrearage, sir?
I do, Judge.
What is
Current
it?
arrearage is $23,871.07.
Okay, gotta get those 7 cents in there. All right, thank you, sir. What has gone on here?
Yes, Your Honor, thank you. I had the opportunity to meet with Attorney Tringle, and we discussed quite a bit. Again, I've reviewed this case to its fullest. This would be the second time that he has absconded from probation. My apologies, Attorney Tringle. The dead time that we have would be, the first time he absconded was 70 days. Second time he absconded was 175 days, which could potentially push his discharge date out to August 2nd of 2027, if Your Honor so wishes to continue him on probation.
Well, let me ask you this. So I originally gave him the 48 months. So I can extend this up to 3 years and then up to 5 years, correct?
At some point, it was extended, Your Honor, because we
Okay.
have him at his max of December of 2026.
Okay.
So now the new discharge date with dead time would be August 2nd of 2027.
Okay, I appreciate that background.
Yes.
Thank you.
Yes, Your Honor. I have learned some things by talking to Attorney Tringle. He lost his house, his father's dying, going through some big life changes. I've spoken to Officer McKenzie, and he let me know that he is happy to assist Mr. Thompson with resources for employment. Probation is also happy to assist him with that. He did do quite a lot of time on probation. I don't show that any additional programming was ordered. He does have 4 prior felonies, all drug related, but there's no testing requirements on this. So I understand that it's just for child support. However, maybe we're missing something here. So if Your Honor is inclined to continue him on probation, I would ask for that new discharge date. I would ask that the drug and alcohol testing conditions be added. And I would also recommend that substance abuse treatment be added as well.
Yeah, I think in the original pre-sentence investigation report, there was just alcohol and marijuana, and he had claimed, I think he stopped using, so appreciate that information.
Yes, of course.
All right, on behalf of the people, anything you want me to know?
So Judge, I believe, yeah, you extended his probation on November 1st. Judge, Mr. Thompson hasn't made a child support payment since January of 25. So it's been a year and a half since he's made any child support payments right now. Again, he does have a $22,271 arrearage. So Judge, I would certainly ask if you can extend his probation to August 7th. But our focus, as always, is going to be on paying, that he's paying back the custodial parent, the person who raised his child.
Thank you. Counsel?
Thank you, Your Honor. I have had the opportunity to speak with Mr. Thompson, and he has informed me that he has been struggling financially, that there's been a lot of life issues that have prohibited him from being able to make these payments. And speaking with him, it does not appear to me that it's a willful failure to pay, rather a lack of ability to pay. I do think he's making a good faith effort to secure employment. He informs me that he has started working with Michigan Works. He has a case manager there, Lisa White, who's helping him. It's my understanding he's only about 10 hours away from obtaining his associates. He's also got the time needed to obtain his barber's license. And she's helping him finish out those so he becomes more marketable and can find some stable employment. Mr. Thompson, during the course of this probationary period, has lost his job, which is why there's that wage assignment is not being fulfilled. He has been struggling to get back on his feet, which includes losing his home and having some, and being unhoused for a period of time, and being unhoused for a period of time. And I most recently being this January to current date. I will note that at the time he was picked up his wallet had been stolen. He didn't have any form of identification on him, but the officer asked his name, and knowing he had a warrant, provided the correct name. I think that indicates that he's not desirous to try to flee from these things, that his inability to, his financial struggles that have even increased over the past 6 months were really the driving force behind his failure to report, rather than his ability, or rather than his desire to not be responsible in this matter. That being said, we would respectfully request that the court follows the recommendation of probation, continues his probation, and gives him 10 days credit, or 10 days with credit for 10 days served. We would also ask that, as probation is continued, that if there's any ability for probation to assist with him finding some stabilized housing, things of that nature, I think that would be helpful. The other thing I would note is that my concern about the request for drug or alcohol testing is that Mr. Thompson is here because of financial difficulty. My concern, he doesn't have reliable transportation. He relies on the bus when he can afford the bus. He doesn't have money to pay the support, which is why he is here. My concern about those testing requirements is solely that if it could create more of a financial burden. And we'd ask the court take that into account.
Thank you. Sir, what would you like me to know?
Yes, Your Honor, I was just like, there's no excuse. Yes, I did. I take full responsibility as far as absconding and not showing up. But I just had a lot of things coming. Like I said, I lost my house. Lost my job. Had 2 jobs. Lost my 2 jobs.
When you were here before, you were a barber, so aren't you still?
No, I still am a barber, but the barber that I used to work for, the shop I used to work for, due to the COVID thing, it closed down. So I never went back. I was working under apprenticeship under them, so I had all my hours in, but I never went down there to take my test because the COVID thing came about.
I see. So
Yes.
You're getting your hours, or you're getting your.
No, I already had my hours. I just got to take the test. I just had to. That's why I'm working with a lady, Lisa White from Michigan Works. She's helping me. She's helping me out.
All right. So how much jail credit does he have? I had, I think, 283 at the time I sentenced him, and then there were 17 days added, so there was 300, and there was another previous violation, so, and plus 10 days now, so I don't know if it's 310 or more than that.
As of today's date, Your Honor, it would be 332, and you did order 365 days jail held in abeyance of unsuccessful completion. Thank you.
All right, so here's what we're gonna do. I'm gonna give you 365 days jail credit for 332 days. The balance is held yet again. We are going to extend your probation. That was August 2nd of 2027. You will find gainful employment, and you will not give your employer any cause to terminate you. Should probation want to drug or alcohol test you, they may do that. They will find some kind of indigency grant or whatever to do that.
Yes.
We're also going to have you engaged in whatever support you can have for housing, employment, bus tokens. I mean, there are options. The problem is, sir, you absconded from probation, and so we were not able to help you. Probation is not the punishment. The punishment is being in that stupid jumpsuit. It's not a very good fashion statement, except that you're a law violator. So quit it, sir. I mean, you got a whole bunch of excuses. There's really no excuse where you can't show up to probation, because they are there to help you. Probation is assistance. It's not a punishment. What you got there, wearing that jumpsuit, being in jail, that's a punishment. And if probation doesn't help you, you got me. And I go against probation, all sorts of other people, when they don't help defendants, when things go wrong. I'm the biggest proponent of, hey, let's fix it, and why didn't you do your job? So if there's a problem, you come see me, and I'm gonna call everybody in and say, why didn't you help him? You've got to speak up. Do you understand it? But you gotta show up in order to speak up.
Yes, sir. I understand that. Can I say something real quick?
Real quick, sure.
Yeah, I mean, I understand that they helped me out. They gave me things for me. That's why I'm going. I picked a resource for the lady at my my caseworker at Lisa White, she's helping me with all of this. Now, that's why I chose her, and she's very good, and she's dedicated to what she's doing, so I appreciate what she's
that,
doing.
sir,
Yes, yes.
but had you stuck with probation, we wouldn't be here, because I would have just said, okay, you lost your job, return pop bottles, pay $5 a week, but you paid nothing. I mean, I do appreciate, and I want to make the record, that at some point you were, I think, $32,702.24. And then you did pay some, so then it got to be the $28,016 in arrearage, and then now it's 23,871.07. So you do have good intentions to pay. I don't always see that with people, so I want to give you credit for that. But sir, I need you to understand, we are here to help you. I have to punish you when you don't ask for help. So please, sir, ask for help. Be the example and get this paid down. If you need employment, training, status, whatever, we're here. So if you ignore us, we ignore you. Except for I do bench warrants and you get picked up. So please work with us. This is for you, not for us. You're costing the county a lot of money when we have to house you. So we gotta work together to get you back on your feet in this child support pay. Can you do that?
Yes, sir.
Great. Anything else I need to order?
No, Your Honor, thank you. I would just like it placed on the record that Mr. Thompson is to report to me by 9 a.m. tomorrow. I'm going to hand him my business card because Agent Meisling is out until next week.
Okay, so can you do that, sir? Can you get a ride?
I mean, I can get it, yes, yes, I can.
Okay, get a
But
ride.
Just in case, I might have a warrant out in St. John's for payment. I don't know, I don't know if they're gonna, I don't know if I do or not, but
Okay, so if you have a warrant out of St. John's, they probably will transfer you to St. John's, but they'll let probation know, thanks for letting probation and me know, so we'll
Right.
check on that, and then what will happen is, sir, you'll report to us 24 hours after your
Yeah,
release.
okay.
Does that make sense to you?
Yes, ma'am.
Okay, no more absconding, ask for help, keep your power and your dignity, don't be in that jumpsuit again, that's all for the
Yes,
record.
sir. Thank you.
Thank you very much, Your Honor.
Thank you, sir. Sorry for the delay today.
problem.
Next, oh, hold on, I've got like, how many more? I've got.
Like two.
Okay, well, we have a 1 o'clock.
I guess that's my question, is do we want Pete first?
Parker next.
Are we bringing two?
Yeah, we already have two.
Okay.
They're already out.
Okay, we're gonna do Mr. Pete next,
So what is that?
another probation violation.
I'll take my shoes off.
I will say it is 12:20, so we only have two more.
Yes, I did across the town at 1 o'clock, so we gotta do 10 minutes each to drive here,
Okay.
or else we reset one.
I will say, I expect Mr. Ali will go quickly, without issue. Mr. Pete will be a little late.
Judge, you want me to take my shoes off in case I have to run up there?
Yeah,
Take my shoes off in case I have to run up there?
you certainly can, although I know.
I'll drop them
You
off.
and I are the same, we can run faster probably in high heels.
That's.
Right?
That's probably very true. I'll keep them on, they can be,
Yes,
yeah, you're right, that's funny.
yeah. Are there any charges against Mr. Pete?
There are not.
Are there going to be?
I have not received anything, Your Honor.
Oh,
For the assault.
no, Your Honor.
Okay.
Mr. B.
Right now. Are yours is answering the door?
You can't hear me?
All right, this is docket 256003FH, Peaceful State of Michigan versus Johnny Ray T. Counsel, your appearance for the record.
Good afternoon, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Agent Farr, Ingham County Probation, Department of Corrections.
Thank you, Your Honor. Amanda Tringle, Office of the Public Defender, appearing on behalf of Mr. Johnny Pete, who's present to my right.
Sir, please raise your right hand. Sir, please raise your right hand. Need more time? Sir, can you hear me?
Oh, how you doing, Your
Good, please raise your right hand.
You're still my favorite judge.
Thank you. You might be my favorite defendant today if you follow directions, okay? All right. Do you swear to tell the truth, whole truth, and nothing but the truth under penalty of perjury?
What's she saying?
Do you have a problem hearing, sir? Do you have a problem hearing?
Just a little bit.
Okay, so we're gonna get you some hearing help. Okay, do you swear to tell the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes,
Thank you. Does that help you hear better?
yes.
Okay, very good. You just gotta let us know. We have lots of help we can provide you if you let us know. Sir, you pled guilty to count one, police officer assaulting, resisting, obstructing, and with the habitual, it was punishable by 3 years. Normally a 2-year, but with the habitual, it was 3 years. And you were placed on probation. I have a bench warrant that says as follows, count one, on or about June 18th, 2026, defendant involved himself in assaultive, abusive, threatening, or intimidating behavior with the staff at Meridian Health Services. Count two, on or about June 18th, 2026, defendant failed to report to Ingham County Probation or any time thereafter. Do you understand those allegations?
Yes.
Are you waiting further arraignment?
Yes, Your Honor.
And sir, have you taken any medication yesterday or today?
Yes.
Is it anything that would interfere in your ability to understand your attorney or this court?
No.
Is there medication you're supposed to be on that you're not on?
This is the medication I'm supposed to be on.
There is some medication you're supposed to be on?
Yeah.
And you haven't taken it?
No, I took it this morning.
Okay, so you're on all the meds, there's nothing you're not on, but you're supposed to. Okay, any sign of fever, COVID, or other illness?
No.
And you had an opportunity to speak with Ms. Tringle, your attorney?
Yeah.
Okay, so as to count one, if he's going to plead, I would take a no contest plea because it appears there are no allegations, but I don't want there to be some that arise, or we can hold this over and wait. And then as to count two, I think that would take a guilty or not guilty plea.
Thank you, Your Honor. We would respectfully request a no contest plea to count one and a guilty plea to count two.
Do you understand that, sir?
Yes, ma'am.
All right, and is it your intention to plead?
Yeah, I plead, no contest.
Okay, as to count one, involving yourself in assault, abusive, threatening, or intimidating behavior on June 18th, 2026 at Meridian Health Services, how do you plead?
No contest.
And sir, as to count two, failure to report to Ingham County Probation since on or about June 18th, 2026, or anytime thereafter, how do you plead? Did you report? Guilty, not guilty, or no contest?
Yes, Guilty?
Okay. Did anyone force, threaten, or coerce you to plead?
No.
Anyone promise you anything that caused you to plead?
No.
You pled because you have not filed probation, is that correct?
It was,
Or we'll get to the excuse part later, but.
no, I'm not making an excuse, I'm just saying, it was just a miscommunication.
Okay, we'll get to that part later, but you would agree that to the letter of the probation, what I ordered, it hasn't been completely filed, is that fair?
Yeah.
Okay, and you had an opportunity to talk about these issues with Ms. Tringle, and you've been satisfied with her representation of you, is that correct?
Yeah.
All right, and sir, I do find that, and I'll listen to your explanation, but I do find that you are in violation by preponderance of the evidence, your own admission, you haven't been here, and the no contest plea acts as guilty, but for purposes of not incriminating yourself. It does appear from everything I have here, report from probation, that there is some kind of behavior that something occurred, and it's clear you have not been reporting to probation. So count 1 and 2 are going to enter. What we do with it now is what we're going to talk about. What's the recommendation from probation?
Yes, Your Honor, thank you. Our office is very familiar with Mr. P, as is this court, as is law enforcement. He was placed on a term of probation in February, and he was reporting as instructed, appeared to be taking his medications, but then once he stopped being medication compliant is when all the problems started. Often when he reports, he is so loud and boisterous that there's a show of force, and there's other agents that stand outside my office to make sure that I'm okay. There have been a couple of instances where I have asked Mr. Pete to sit down if he abruptly stands up, or to back up if he's too close to me. I don't think Mr. Pete would ever hurt me, but he needs to understand that there are boundaries that he has to follow, and we've discussed that.
So can I ask you, it seems to me he's got a hearing issue, and that might be why he's loud and why he gets close to someone. Is there some service we can provide to him so he gets a hearing aid? I think a hearing aid is complicating matters.
That's $1,400.
I know, but sir, there are services for indigencies so that you can get your medical care, and we can help you with that if you show up at probation.
Oh, okay.
You gotta show up, sir.
Yes, I will.
Your Honor, I hear what you're saying, and I definitely can look into that. However, it's not just about being loud, it's like the language that he uses, how he talks about situations that he's been in. So it can be deemed as intimidating or assaultive in nature.
Certainly understand.
Okay, thank you, Your Honor.
Yeah, and can you tell me, has he completed anything on probation?
Your Honor, I have tried to get verification from CMH for his treatment there with therapy and medication reviews. I have left voicemails, I have sent emails, other than sending a pigeon, I have not heard back from them.
So has he signed a release?
Yes, there is, and so I'm not sure why, because I've heard.
I'm happy to, and I don't mean to cut you off, but time is short this morning. I think the people or you and council can get together. I will sign a subpoena. I mean, if they're gonna ignore me, then I'll hold them in contempt. We absolutely need what you're saying. And I know you go extra miles for what you need, but you don't have the time to waste. And so I am happy if y'all get together and do a subpoena and request what you need specifically to be turned over to you, or show cause why they can't, then I'm all for that, because we can't serve people if we don't have the right information, and he certainly does need some services.
Correct, Your Honor, thank you. So you held 365 days jail and abeyance at sentencing. He has been in custody right now for 4 days, 24 days, so 28 days total since sentencing. Your Honor, I don't want him to.
Isn't it 30? I had 26 days jail credit at sentencing.
I have 24, unless my eyes read wrong.
I wrote 26.
You did?
So it'd be 30 days.
My apologies.
Okay, it's okay, we just got it, so 30 days credit.
30 days credit as of today's date. It is so tough to supervise Mr. P. There unfortunately is not enough services that we can offer him to help him with the level of mental health issues that Mr. Pete has. And if he's not going to take his meds,
Okay, let me ask you this.
Yes,
Can we
sure.
perhaps send him over to Judge Jago? Mental health court would be appropriate for him.
He's been denied in the past, Your Honor. He is
Why was he
a
denied?
registered sex offender.
Oh.
So he has been denied in the past, because we did look into that, Your Honor. So, I mean, I can't recommend revocation at this point. He would have to voluntarily ask to be revoked. It's just, he would be great for adult foster care to reside in a home, but he won't. And then the other clients would be at risk because he has such an assaultive history.
Okay.
I'm just doing my job, Mr. Pete.
We're good.
So,
Okay.
yeah.
On behalf of the people?
Your Honor, I would defer to probation in this matter.
Thank you, Your Honor. And speaking with Mr. Pete, I think, well, first let me say, I do think you hit the nail right on the head when you discussed the hearing issues and perhaps why he's loud and stands close to each other, or stands closer to people than what they may be comfortable with.
Social worker work with him to get some services?
I can request so, yes.
Okay. Anything else?
Yes, Your Honor. I would just note that and I have not been able to get confirmation as I was just appointed to this matter, but a couple of days ago. However, I was speaking with Mr. Pete. It's my understanding that first, let me point out that the failure to appear was June 18th, or failure to report to probation was June 18th. Mr. Pete informs me that he did on approximately Friday, June 26th, go to Forest View Psychiatric Hospital in Grand Rapids for some psychiatric treatment. He was there approximately 2 weeks before he was released on July 10th. And then I'd also just like to add that he, I will say that he was concerned when I spoke with him that they were supposed to email his probation officer and hadn't. Although when I spoke with Ms. Barr, she did indicate that she did receive a call from them advising that he was there. They just did not confirm the dates of that he was present. But I'd also note that when he was picked up on this matter, he was at
Greenlawn Hospital.
Greenlawn Hospital, a CMH wing. Or facility, from my understanding. And so I just want to say, or I point to those things to say that he has been struggling lately, but he's also been seeking assistance.
Sir, are you on SSD or SSI? Are you receiving help, public assistance?
Your Honor, he took his hearing off, so I don't know if he can hear you.
So we gotta leave that on. Are you receiving SSI or SSD?
Yes.
So are you also getting Medicaid, Medicare?
Yeah, I had Medicare.
So have you asked for a hearing aid? So you need a hearing aid?
Yes, I know, Your Honor. They told me that I would pay half and then the other half would be $1,400, which I think kind of steep.
Okay. Is there, Ms. Farr, is there any resource we have to get hearing aids? Maybe the social worker can help?
I'm happy to look into it, Your Honor.
All right, here's what we're gonna do. I'm going to ask that your social worker forward probation to get him his hearing aids, that he avail himself of psychiatric treatment, sign the releases, you all work together, and I get, just a minute, we'll get all of the paperwork and see what we can do, and I'm going to reduce probation. Yes, sir?
I have a good, what you just said, social worker at CMH, her name is Marcy Nelson.
Okay. Well,
She
can work with probation to get all that for you.
Yeah, she's a really good worker and she goes out her way to help me out.
Okay, Well, you gotta go out of your way to be kind and wear your hearing aid, because I think that people think you're loud and dangerous because of the way you act. You're not a tiny man, and so you get loud and they get scared. So we need to get you the hearing aid.
Okay,
Okay, so I had you on a period of 24 months probation. I'm going to put that at,
I thought it was 18.
is it 18?
Yes, Your Honor.
No, I have, all right. I'm gonna put that at 9 months. And the reason I'm doing that, once we get him stabilized, I think this is more of a CMH kind of issue than a probation. And so once you get him stabilized, once he does have his probation, I'll release him.
Yes, Your Honor.
So it's gonna be 365 days jail credit for 30, the balance is held. Once he's stabilized, gets his services and is following the law, we'll release him into the hands of CMH. Does that make sense to you, sir? So you're gonna be free, you're gonna follow the law, you're gonna work with everybody to get hearing aids and all your meds and everything. And then we're gonna release you from probation, but you work with Ms. Farr.
Am I going home today?
You certainly are.
Yes.
But you gotta behave, sir, because otherwise I gotta put you in that.
I love you, Miss Aquilina.
Well,
Judge Aquilina.
then here's what you do. You keep our community safe, and you get your hearing aid, and you follow the law.
And I
everybody's
love
safe.
my probation officer as well.
She's
I
great.
don't mean to scare her.
She's great. I'm glad you love everybody, but you'll actually prove it by doing well, okay?
And I love my lawyer too.
Okay, great.
And officers too.
You got a lot of women here behind you, but you gotta do the right things, okay?
Yeah.
Okay, you better love the law enforcement too.
Yeah, I love
They're
them too.
feeling left out.
It's this big baby right here.
All
And they
right.
call him Big Baby. He's not a little fella neither.
No, I'm sure he can take you out, so don't make that happen. All right, thank you.
Thank you so much, Your Honor.
Thank you, Judge Young. Oh, thank you, thank you.
Mr. Pete. Mr. Pete.
All right, I've got,
You report to me tomorrow morning.
Oh, yeah.
no, how long is this gonna take?
He's gonna plead,
We'll see tomorrow morning.
To what?
Behave.
Yeah.
by
Yeah.
failure to
Oh, yeah.
report, it's less than 60 days, they're both technical violations, failure to report and change of residence without approval.
Okay, let's do this quickly.
Okay.
I'm very happy he's happy. I guess I'm now in the happiness business.
I was just talking about that the other day.
Yes.
You have no idea.
Well,
Yeah, we'll just do that.
you know, that's the case of stabilizing the release. So,
Thank you.
you see the method to my madness.
I
right?
love how you think outside the box and yes, I love, that's such a great idea.
Yeah,
Thank you.
well, you know, we don't often know until they're put on probation and things happen. That's why I
Yeah.
appreciate all your work.
Yeah, of course.
So, all right. Okay, where is he? Is he coming up?
We're bringing him out.
All right, this is docket 25-4217 FH, People of the State of Michigan versus Royce Ali. Counsel, your appearance for the record.
Royce Ali.
Good afternoon, Your Honor. APA Bart Luxon on behalf of the people of the state of Michigan here at probation.
Agent Mike Province for probation.
Thank you, Your Honor. Amanda Tringle, Office of the Public Defender, appearing on behalf of Mr. Royce Ali, who's present to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
And sir, have you taken any medication yesterday or today?
No,
Are you supposed to get medication you're not on?
no,
Any sign of fever, COVID, or other illness?
no.
You had enough time to speak with Mrs. Tringle?
Yes.
Okay, if you need more time during this, please let me know. And sir, you pled to possession of a controlled substance known as cocaine, less than 25 grams, punishable by a 4-year short callback.
Yes.
And now I have some technical violations on or about June 4th, 2026, or anytime thereafter you fail to report to probation as instructed. Count 2. On or about May 29th, 2026, defendant changed residence without notifying probation. Are there any amendments on behalf of probation?
No, Your Honor.
All right, and that's why I had to sign this warrant. You didn't show up, so June 10th, I signed this warrant. That's why you've been arrested. Do you understand, sir?
Yes, ma'am.
And counsel, you waiting further arraignment?
Yes, Your Honor.
Will this be a plea or a hearing?
This is going to be a plea.
All right, sir, as to failure to report on or about June 4th, 2026, how do you plead?
Guilty.
And as to on or about May 29th, 2026, changing residence without notifying probation, how do you plead?
Guilty.
Did anyone force, threaten, or coerce you to plead?
No, ma'am.
Anyone promise you anything that caused you to plead?
No.
You pled of your own free will?
Yes.
And you did that after consulting with your attorney?
Yes.
And you've been satisfied with the representation?
Yes.
All right, and sir, you understood that you needed to report each and every time, no less than one time per month, we talked about that sentencing, right?
Yes.
And you also needed to report within 24 hours any change of address, cell phone number, or personal protection order, all of that whole list, and you
Yes,
failed
ma'am.
to report your change of residence, is
Yes.
that correct? All right, and are you still employed?
Yes.
All right, and well, based on your acknowledging the failure, I'm finding that count 1 and 2 should enter. What is the recommendation? What has he accomplished so far on probation? On behalf of probation?
Your Honor, the defendant hasn't accomplished anything. I had to chase him down for over a week. It was just shy of it requesting a warrant for failing to report for even following sentencing before I received a phone call from a third party using three-way call to connect with him. He reported the following day as instructed, then failed to report the next week so we could finish orientation because he showed up so late on the day he did report.
Okay.
After telling me that he was living in Ann Arbor all of a sudden. The defendant has shown manipulative behavior by telling his Wayne County agent, as he's on probation through Third Circuit probation, that he was living here in Ingham. And that was at the time he was still completing sentencing here.
Do you have his current address now?
He's homeless.
Okay.
He told the Ingham County agents here and at sentencing that he was living down in Wayne County.
Okay. What is the recommendation?
Recommendation is, since he's a flight risk and the underlying issues involved controlled substances, probation is recommending that he be remanded to custody pending transportation to TRICAP to complete the TRICAP OMSP program, or if he's not found eligible for the OMSP program, the regular TRICAP residential substance abuse treatment program, where he can complete multiple programs, including the ordered CBT program. Probation recommends that following completion of TRICAP, he be ordered 90 days curfew MDOC tether, and that in addition to this, probation, both in Wayne County and myself, have received allegations of the defendant residing at the Somerset Apartments with an uncle. The allegations included potential illegal behavior, including selling drugs and prostitutes. There has been no law enforcement evidence of this, but since the defendant was found and essentially trespassed from that residence when he was arrested on this warrant, probation would recommend that a no entry condition to the Somerset Apartments on 1401 Holmes Road be included as well.
Thank you. On behalf of the people?
Your Honor, the people would defer to probation.
Thank you, counsel.
Thank you, Your Honor. Mr. Ali was just placed on probation May 20th. He has experienced housing difficulties and he's been unhoused during this period. In speaking with Mr. Ali about why he wasn't forthcoming with that, he indicated his fear was that he would be incarcerated because he didn't have a place to go. He also apparently indicated that to his probation officer when they spoke after a period of time, and the probation officer set up or indicated a shelter where he should go. And speaking with Mr. Ali, he did go, and there was no beds available, so he wasn't able to stay. The fault of Mr. Ali was to not update the probation officer about the fact that there was his address at that point. I think these violations have everything to do with his housing instability. He and limited income. If the court looks at this as one violation, the maximum possible jail penalty would be 15 days. If you view it as two, it would be maximum 30 days.
Under what are you getting that?
Under the technical violations from MCL 771.4B. But that obviously does not does not stop a remand or a hold pending transport to an eligible treatment facility.
So as to the recommendations of TRICAP and the MDOC tether and all of that, plus I had originally, although this might be technical violations, I had originally sentenced him to 365 days jail and held it in abeyance pending all this. So I don't know, I guess we can argue about the jail time. What I'm interested in is what about the TRICAP recommendation and all that?
In speaking with Mr. Ali about the TRICAP recommendation, he welcomes that. He thinks that I did explain to him that it can, at that facility, he can get his programming completed that's ordered through probation. And there's some things that can help stabilize him so that he's better, or in a better place to fulfill his terms.
Thank you.
It is my understanding he has a hold out of Wayne County. And he may be transferred there before he's eligible to go to TRICAP. However, we would request that he is entered into the TRICAP program at the first or at the earliest opportunity.
Sir, anything else you want me to know? You willing to go into treatment?
Yes, ma'am.
All right, so if you end up homeless, if you end up whatever, you gotta tell us, because otherwise that's exactly where you do go, is jail. When you talk to us, you don't go to jail.
Yes.
When you ignore us, you end up in that jumpsuit and you end up housed in jail. And I did give you 365 days jail, so I really don't care about these violations. Because it did give you, I held it in abeyance looking at your, how you would do, and you've done a crappy job. And so I can impose what I held in abeyance. So, sir, if you wanna piss me off, go ahead and keep violating and you will find yourself in jail, maybe prison. This probation is meant to save your life.
Yes, ma'am.
Now, if you don't think your life's valuable, then I need to do some extra counseling for you.
Understood.
So do you want to be a free man who's a clean man from alcohol, substances, illegal drugs, criminal activity, or do you want to be an imprisoned man?
No, ma'am, I want to be free from the nerves and drugs.
Then you have the keys to the jail. You have the keys to the prison. You gotta do the right things, or I have the authority and I use it, and I will make sure that you are behind bars for the safety of you first and foremost, and the safety of the community. So make your choice wisely. If there is a problem, probation is not there to punish you. It may feel like a punishment, but jail or prison is the punishment.
Yes, ma'am.
Being in that jumpsuit with those handcuffs is the punishment.
Yes.
Probation is to help you, help yourself. They have the resources. If there's a problem, either one of you or both come to me, or your lawyer comes to me. We figure it out together. This is a joint party. If you want to swim alone, it's called prisoner jail.
I don't want that.
Well, then, this is a group activity. You gotta do the work, but we're here as your support team. If you don't want us to support you, that's exactly where you go, behind bars. Got it?
Yes, ma'am.
Great. All right, so, I had already placed him on 12 months probation. It's now 24 months. I think we need time to stabilize him. If you're doing well after 12 months, you certainly can ask to be released at that time. How much jail time does he have now?
Your Honor, with the new arrest, it's 13 days for this. I previously had
So it'd be
42, so
55?
total of 55, yes.
So he gets 365 credit for the 55. Then he'll get credit for any other jail time, but he will go from jail here or from Wayne County, as the case may be. I don't run the other jails. I don't know what's gonna happen there. He's gonna go to he's gonna remain incarcerated until he goes to the specific TRICAP program. If that's not available, go to any other TRICAP program that he is available to participate in, or any other program. I just want him to do long-term residential intense treatment, and including the aftercare. The 90 days MDOC tether makes sense to me, and all residences must be approved. The Somerset request, there's no entry there, is also granted. So you will amend the probation orders, is that correct?
Yes, Your Honor.
All right, and then, sir, you need to sign all necessary releases so that we can verify that you're doing what you need to do. And I suspect that if you tell the Detroit judge, hey, Wayne County, Ingham County told me to do this, they may very well do the same thing.
Okay.
So I would respectfully, if I were you, ask the judge to follow my recommendations and then sign releases so they too can see the progress that you're making and everybody can work together. And then wherever he's living, your residence must be approved. So if it's in Ingham County, we're going to monitor you. If it's in Wayne County, they can monitor you, but you have got to be monitored wherever your residence is. And if you decide to leave us, we're gonna find you. They know who you are. And I've told you what the consequence is. I'm not wasting county time dollars or my time or council or probation on a guy who doesn't want to be helped. Prove to me you need help and want help and that you are going to be a success. Because I put you on probation because I think that you're worthy of this. I think that you can be a success. But if you don't want it, we have other things that I can do and will do. Do you
I don't want to
understand?
push you off, yes, ma'am.
That's really good. I like that, sir. So I look forward to successfully discharging you. Any questions?
No, ma'am. Oh, if I have any problems, anything, reach out to him.
Yeah, we talked to probation. If you need some co-counsel on him, we're gonna do it. We're gonna get you the help you need, but you have got to ask for help.
Yes, ma'am.
We are not mind readers. My road comes with a gavel, not a crystal ball.
Yes.
So help me out, sir.
Yes, ma'am.
Great, thank you. That's all for the record.
Thank you, Your Honor.
Thank you, Your Honor.
All for today.
That's for sure, not appreciated.